Mr. O'Mara, did you want to take the moment to,
Yes. Moving into evidence, I believe there's no objection from the state. What is an affidavit and declaration of custodian of records from Sanford Police Department? Taking out the summary. This is my summary, but it's not an official record. I talked to Mr. Delarionda. I'd leave it in, but it's I created it.
Did he approve? Did he approve it?
No, I'm taking it out of the, yeah.
okay, so that declaration from the city of Sanford will come in without objection
Correct.
as Defense Exhibit 25?
Mr. Delarionda is who I spoke with, so I don't want Mr. Guy and
Yeah, Judge, if we could just wait till he gets back, I think
Okay.
it's okay.
And then, well, what I also will announce, just so we're clear, and then Mr. Delarionda can finalize it, is
Here he is.
oh, great. Mr. Delarionda was just putting in the evidence or the exhibits we had talked about. I took off.
Yes, I apologize.
It's okay. I took off the summary, so that's not in it.
Right.
But
We
the
have,
rest
we have
is.
no objection to that, Your Honor.
Okay, and it'll come in as Defense Exhibit 25. What is the next one?
Next one, Your Honor, is the letter documenting that my client, from Florida Department of Agriculture and Consumer Services, documenting the existence of my client's concealed weapons permit and a very poor copy of it.
Any objections?
no objection.
That'll come in as Defendant's Exhibit 26.
And the last one is the the CD and the event report documenting the sixth of 6 calls that my client placed in the past 6 months before the event. The state had played 5. This is the last one. And
Any
We have no
objections?
objection to that.
Okay, that'll come in as Defense Composite Exhibit 27.
I
That's it?
I believe that's it, Your Honor.
Okay.
There was, and Your Honor, the layout that was presented, the state has no objection to it being entered.
Okay, and that would be Defense Exhibit 28. We could call that a still board of the crime scene.
Thank you.
Okay, you want to look through your stuff and make sure you have it all?
Yeah, I think we do. There are a couple more we'll enter, but we'll do that just for the court's planning purposes. We have this witness, which we'll finish, then there are 2 very short witnesses.
Okay, Mr. Zimmerman, sir, I spoke with you this morning about your rights to testify if you want to, and the fact that you do not have to testify either. The jury cannot consider that in their deliberations of whether you testify or not. Did you have an opportunity to talk to your attorneys about whether or not you want to testify in this case? Do you need some more time to talk to your attorneys about that?
No, Your Honor.
Okay, and if you'll please just raise your right hand for one moment.
You solemnly swear affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Okay, and Mr. Zimmerman, like I said before, you're aware that during this trial you have the absolute right to remain silent. You do not have to say anything, do anything, or prove anything. Is that correct?
Yes, Your Honor.
And you also have the right to testify if you want to. Do you understand that?
Yes, Your Honor.
And I've given you an opportunity to discuss with your attorneys whether or not you want to testify in this case, and you have indicated that you have had those discussions.
Yes, Your Honor.
And have you made a decision, sir, as to whether or not you want to testify
Your
in
Honor,
this case?
I object to that question.
Okay, overruled. Have you made a decision as to whether or not you want to testify in the case?
I object to that question. I think that's Mr.
Overruled. The court is entitled to inquire of Mr. Zimmerman's determination as to whether or not he wants to testify. Mr. Zimmerman, have you made a decision as to whether or not you want to testify in this case?
No, not at this time, Your Honor.
Okay, and when is it that how long do you think you need before you make that decision?
Your Honor, may we have an opportunity to speak? The case isn't concluded yet.
I understand that, And I've asked Mr. Zimmerman if he needed more time to talk to his attorneys, and if he does, I will afford it to him. Mr. Zimmerman, how much more time do you think you're going to need to discuss this with your attorneys?
I assume it would depend on how long the recesses are, Your Honor. At the end of the day,
Okay, well, if your attorneys have finished with 2 witnesses before the end of the day, do you think that you would then know whether or not you want to testify?
On Mr. Zimmerman's behalf, that
I am
decision.
asking your client questions, please, Mr. West.
I object to the court inquiring of Mr. Zimmerman as to his decision about whether or not to testify.
Your
at this-
objection is overruled. Mr. Zimmerman, I will give you more time, sir, to discuss this with your attorneys. Thank you very much.
May I approach on an unrelated matter from-
Yes, you may. Mr. Root is here. Are we ready to bring the jury back in? Oh, okay, let's go ahead and bring the jury back in.
Jurors present, Your Honor.
Please be seated. Welcome back, ladies and gentlemen. I hope you enjoyed your lunch. While you're getting settled in, I'm going to ask you my questions. If your answer is yes to any of the questions, please raise your hand. During the lunch recess, did any of you have any discussions amongst yourselves or with anybody else about the case? No hands are being raised. Did any of you read or listen to any radio, television, or newspaper reports about the case? No hands are being raised. Did any of you use any type of an electronic device to get on the internet to do independent research about the case, people, places, things, or terminology? Thank you. No hands are being raised. And finally, did any of you read or create any emails, tweets, text messages, blogs, or social networking pages about the case? No hands are being raised. Thank you very much. Mr. O'Meara, you may continue.
Thank you. Good afternoon, sir. When we broke, I was just beginning to talk to you, and I wanted to go back to your cross-examination and a couple of questions that came to mind. You were asked by Mr. Guy whether or not you had listened to what we are calling the non-emergency call, which is the one in which Mrs. Zimmerman says words, some expletives. He says assholes and some other words. You remember having reviewed that?
Yes, sir.
And you were asked a question whether or not, in context of Mr. Zimmerman's presentation, if that evidenced to you some type of anger or frustration or whatever it was by Mrs. Zimmerman. Did you had an opportunity in your experience as law enforcement to hear people in angry, upset, and frustrated ways?
Yes, sir.
Okay. Have you actually been involved in situations where you had to try and break up disputes, be they domestic disputes or fights, where people are yelling and screaming at each other?
Yes, sir.
And has that been sort of throughout the entirety of your career?
Yes.
Is that just one thing that police officers do as a part of their job?
Yes, sir, it is.
Have you seen and heard people in various states or stages of anger and hatred and ill will as they're yelling at people or each other?
Yes.
Using that basis as an experience foundation for your testimony to this question, was any of that evidenced to you in the way Mr. Zimmerman said the words assholes?
The way I interpreted the way he said or used the verbiage that he used, it was more of a frustration about the totality of everyone he's called in on or an element in and of itself, not specifically one particular person. My interpretation of the comments he made were, in general, that they always get away.
So in that word, assholes, did that evidence to you, based upon your experience, any level of ill will, hatred, or spite for Mr. Martin?
No.
There was another expletive that Mr. Guy questioned you about. Could you even hear the words effing punks when you listened to the tape?
Initially, no. That was something that you really had to try to break down and listen to.
At some point then, when you went back to listen to it enough to hear it, did there come a time when you were able to go back and listen to it enough where you actually could hear the words?
Yes, the interpretation, but again, it was after being told they were there.
Similar question then, based upon your years of law enforcement experience, did those two words evidence to you any ill will, hatred, or spite that Mr. Zimmerman evidenced towards Trayvon Martin?
No, not individually.
And it was your understanding from your review of that telephone call that the frustration was aimed towards whom?
I would say
That is calling for speculation.
There were two questions that Mr. Guy asked you, and that was one about a responsible gun owner and two about other options that Mrs. Zimmerman may have had. So keeping those two questions from Mr. Guy in mind, was there anything in Mr. Zimmerman's use of his firearm that you would consider to be reckless?
no,
Why not?
because the use of the firearm was.
Judge, I'm going to object as to the motion previously heard.
I might be heard on that. This question was,
Okay, well, then approach.
yes. Can I continue?
Yes, you may.
Mr. Root, based upon your training and experience, was there anything in the way Mrs. Zimmerman handled his weapon that night that was dangerous? I mean, obviously danger whenever you shoot a weapon, but did he do it in a way that was unreasonably dangerous?
No.
Again, I'm going to object to the same objection as to our limiting motion.
Okay, overruled. Move on to your next question, please.
Yes, Your Honor. And I told you about two questions that you were asked. The other question was whether or not, in your opinion, based upon the facts and circumstances that existed at the time of the shot, whether or not Mrs. Zimmerman had any other options available to him.
Again, Judge, I'm going to object to this calm speculation.
Thank you.
I think he's already testified as to options as a response to a question from you, so overruled.
Judge, and I would object to, again, the limiting motion and the content of his answer.
Overruled.
So, Mr. Root, based upon your training and experience, and knowing what you knew about the facts surrounding the event that night, particularly at the moment of the gunshot, did Mrs. Zimmerman have any other options?
Based on my knowledge and understanding of him, the environment, the situation, totality of everything, I don't believe he did.
There was inquiry as to whether or not you took this case on for the pure notoriety of it. I want to ask you some questions about that. Did you? Is that the main reason why you took on this case?
Absolutely not.
For whatever purposes, certainly with some of the benefit of having a high-profile case, does that or has that impacted in any way on any of the answers to your questions presented either by me in direct examination or in cross-examination?
No, because the same type of negative media coverage comes from this case as positive media coverage. Nothing had any influence on my answers other than my evaluation of the facts as I understand them from this case.
Does the possibility of some future payment to you from me for your testimony here today, did that impact at all in the way you presented your testimony?
Not at all.
The question was posed as to how many times you've testified as an expert. I think you said this is your first time testifying in a self-defense case?
In a criminal trial, yes, sir.
How many times have you testified in a criminal case?
Oh my, I couldn't quantify a lot. I mean, throughout a 22-year career in law enforcement, many times.
Okay, have you ever been cross-examination by a prosecutor?
No.
Normally you are actually on the side of the state, correct?
Yes, this is a complete opposite of where I normally sit.
I want you to presume for a moment that you don't have any information about where the fight started. Forget the location of Mr. Zimmerman's little small flashlight or anything else like that. Focus for now just on the 40 seconds of screaming and the injuries. With that set of circumstances, would you change your opinion at all about Mr. Zimmerman's lack of options?
No, I would not.
Would your opinion be the same even if there was 2-minute delay between the ending of Mrs. Zimmerman's phone call and the event that happened which caused those injuries?
No, that would be irrelevant to me.
What are the only real relevant factors that you look at when, in this case, when evaluating the use of force?
The primary elements that I look at are the event as it's unfolding at the moment that the use of force was taking place and the perception of the individual involved in the event itself. What did they perceive their position to be presented as? That's the ultimate thing that I have to look at when I look at a use of force case and come down to the nuts and bolts of things. It's at the moment the force was used, given everything else, at that moment, the perception of that person that was using force, what was their perception at that given second, and how would that affect the outcome?
Okay, we talked about the flashlight for a moment, the keychain flashlight. Did finding or noting that keychain being there, was that relevant at all in helping you determine where the altercation may have occurred or begun?
It helped create a picture in my mind as where it's possibly started at.
You were asked about blood flowing down or blood flowing back. In your experience, both from law enforcement and I guess more particularly from your experience as a, do we call you a fighter? Is that,
Sure.
Okay, as a fighter, what happens when you get hit in the nose?
Well, there's a variety of things that take place with a nose strike. I mean, there's one of the most immediate things because of the nerve at the base of the nose with a nose strike. It can cause immediate tearing of the eyes. If the blow is significant enough and it does result in bleeding, there's a free flowing of blood, which, depending on the person, how it's flowing and so forth, it can fill the nasal cavity, drain out of the nose, but that can have an effect on your ability to breathe. Obviously, the most primary effect that it would have, in addition to injury, is the stunning effect that it can have on a person.
And in your experience with fighting MMA and other types, is getting in a blow like that early in a fight significant?
The training and everything behind it
Objection,
is...
Your Honor, it's calling for speculation.
Sustained.
If you were in a fight and want to get advantage over the other person, would a strike to the nose accomplish that?
Objection as to relevance and speculation.
Could be heard, but I don't want to.
Pardon, well, I don't know if that's in his experience or not. So,
Let me do a foundation.
Thank you.
You've been a fighter, correct?
Yes.
Just to remind the jury what we talked about this morning, you've actually done kickboxing.
Yes.
Does kickboxing include kicking and boxing?
Yes, basically it's boxing, and you have to have a minimum of 8 kicks per round to basically maintain the level of kickboxing, but it's using your feet and your hands.
Okay, and as part of using your hands, you strike body blows, correct?
Yes, punching
And do you ever try and hit somebody in the face?
repeatedly, yes.
Okay, is that sort of a target focus for you as a fighter to hit somebody in the face?
It is, especially with the jab.
Okay, and with that as an experience basis, how successful is getting in the first shot to the nose in a fight?
Getting the first shot into the face or into the person, it can provide a various outcome. The primary thing is you let the person know you're for real, and it's devastating, especially if you have a hard punch. You know, the rule of thumb for us in training and everything else is the fact that when a punch is thrown, if you're the recipient, and you take that punch, that first strike, which is generally speaking 100% of what the person has because they don't try to just half hit you, you've taken a majority of their power, and if you survive the first punch, you can stay in the fight. For somebody that's not well schooled or doesn't have the same ability, it can have a devastating effect. So getting the first strike in and setting the tempo of the fight and letting the person know that you're on the attack and you're the person in control of the fight is very important, and especially in any combat type art, because he who controls the ebb and flow of the fight, the rhythm of the fight, generally can become victorious.
And you've seen this picture before, of course.
Yes, sir.
Is this consistent with a strike to the nose?
Yes, sir.
If this was the first strike of the fight, would it be, as you testified, a significant maneuver to control the ebb and flow of the fight?
Judge, I'd object to this calling for speculation.
Based upon his experience and training, Your Honor.
But you're showing him a picture of something else, so you need to ask a different question, rephrase it.
Yes, Your Honor. You talked about your criminal justice degree, correct? But you talked earlier about the police academy. I want to see if there's any difference between the two. In your training, well, it's going to be difficult, but because you got your criminal justice degree after you started training as a law enforcement officer?
Oh, yes, I pursued my degree
Okay.
well into my career.
I'm going to try and separate the two. Did you learn any of your striking techniques or resistance techniques or takedown techniques in school for your criminal justice degree, or was just that in the academy and your further law enforcement training?
There was no physical courses like that required in my criminal justice degree. The criminal justice degree is geared toward more to educating you about the criminal justice system, about the courts, the processes, and things like that. The academy is about applying the enforcement of the laws. What laws are to be enforced, how to enforce them, physical ways to enforce it, how to conduct traffic stops, how to conduct everyday business as a professional law enforcement officer, whereas a criminal justice degree is kind of like the bookend, if you will, of criminal justice. It's how the system works in and of itself.
And having done it for now, I guess, 20, 25 years, did you enjoy being a law enforcement officer?
I did. I enjoyed being a police officer very much.
You think that it was, for you, a noble profession?
Absolutely.
Would you encourage or discourage, say you had a 20-year-old nephew or son, would you encourage them or discourage them from taking on a life of law enforcement?
Depends on the child. I have a stepson, for example, very physically fit, and I would encourage him without question to pursue it. My daughter, on the other hand, who doesn't like confrontation, who doesn't like that, I would not encourage that. But anybody who really wants to make a difference and is able to take on the stressors of that type of position, it's a very noble career, and I would recommend it to anybody.
You had mentioned early in the conversations about sort of the continuum of force, that a certain act can allow a response. So if you say to me, go over there and sit down, and I go, no, or even more colorful words, then you get to respond verbally. Is that sort of part of what we're talking about?
That's a piece of it, yes.
Okay. So, and that continuum of force sort of goes up the scale all the way and ends at deadly force, correct?
Yes.
Okay. And are there markers along the way that allows you to increase your response to force?
Absolutely.
So let's just say that I walked up to you and pushed you. What would an appropriate increase in force be based upon your training and experience?
I'm going to object as to relevance, as this relates only to police officers.
I'll broaden it. I want you to answer the question based upon your experience as an adult, based upon your experience as a fighter, and based upon your 20 years of law enforcement experience, and also based upon your expertise in looking at use of force events. So with that context, let me ask you a couple of questions about that. When you look at use of force events, does that go across the spectrum of use of force?
Yes.
Okay, we're not just talking about, you don't just specialize in use of force of deadly force, correct?
No, use of force is force, whether it starts from the very beginning, from verbal communications, and goes all the way up to and including deadly force. It's a very wide playing field.
So if you were aware of a situation of one of your, cadets or one of your people that you would end up helping to train, where they were just using inappropriate verbal force, screaming too loud or doing whatever, would you then counsel those people? Maybe I'm not saying it right.
Yeah.
Let me try again. When you do your use of force training within your experience, both law enforcement and as a trainer, does that include training law enforcement officers and whoever wants to be trained as to how to use even verbal force, where you use the command voice?
All of our force training, whether it's law enforcement or for individuals, the idea behind any level of training related to force is to explain the variables involved in deciding how to apply force and what justifies it. If somebody's being verbal, obviously we would recommend to them that if possible, our number one recommendation for everybody, if confronted by an aggressor, is try to avoid it if you can. But it all depends on your environment, your ability, the ability to leave, the ability. Sometimes people don't give you the opportunity to leave. Sometimes they could be yelling at you from 40 feet away. So all of these variables come into play. So when you look at each event, you have to take into consideration all of these variables. So if I was yelling at you and cussing at you from 40 feet away, my recommendation for you would be just to, you've got 40 feet, walk away, clear the area. If I'm up in your personal space within 6 feet, 3 feet, within arm's length of you, and now I'm getting that same hostility and everything, and I'm very animated, now that verbal confrontation becomes a more significant issue for you because of the distance that we've closed. So really, it's very difficult to answer A and B because the totality of everything comes into play when you consider when and how force should be used.
Okay, so going back to my question I asked a moment ago, we were outside in the courthouse and I walked up to you and pushed you on the chest. What would your response be?
My
Objection, Your Honor, again, as irrelevance and speculation.
That was where I laid the foundation, Your Honor, as training experience.
Overruled.
My personal response, if you shoved me, I mean, again, we're taking this just you walked up blind and pushed me, I would take a position of advantage and give you strong verbal commands and make sure that it was very clear to you that you made a mistake.
Would you punch me in the nose?
Objection, Your Honor, as irrelevance and speculation.
Again, it's training and what level of response he would have.
But you're asking him what he would do in a situation just at that,
I'll move on, Your Honor.
self-sustained.
Move on. I might just have a moment. Thank you very much, Your Honor, for the question.
Recross.
Mr. Root, you would agree with me that your understanding of what was happening at the exact moment of the gunshot comes from one person and one person only, correct?
Yes.
So your opinion that there was another option is based on the words from his mouth, right?
No, sir.
Did-
My opinion
Did you talk
that
to
he
somebody
didn't have
else?
any other
Sorry, Your
options
Honor.
were
You could be allowed to answer his question.
my opinion that there was no other options was based on the totality of his training background and experience. The options that you're referring to really come into play based on what you're capable of doing, not simply just because this event's happening, you have another option.
Don't the options also depend on what the other person is doing? In this case, Trayvon Martin?
Well, absolutely.
So your determination as to what Trayvon Martin was doing at the time he was shot came from him, right?
That was one of the elements that I considered for that. But when you take the small portion of weight given to a statement and then you add in the other evidence that surrounds the event, the injuries and everything, to see if it corroborates it to a point that it seems plausible that this exactly is what took place, and everything lines up to say, yes, based on what I see here physically, the injuries and so forth, this all makes sense. So the opinion is that based on what he told me in combination with all the other variables involved, that's how I formed my opinion.
Yes or no? Do you know what Trayvon Martin was doing at the moment he was shot?
Yes.
You do.
You're asking my opinion. Based on the information I was given the opportunity, just like I could look at you and say, I don't know what Mr. Zimmerman was doing, I don't know what Mr. Martin was doing. If you're looking for me to say that I don't know if Trayvon Martin was doing this one specific thing, we're talking about the totality of how I formed my opinion. But you're asking me about what was he doing at that time. it appears clear through the evidence. If you want me to just surmise and say that, well, based on your perspective, he wasn't doing this or George Zimmerman wasn't doing that.
I don't want you to surmise anything. I asked you a very simple question. Do you know what Trayvon Martin was doing at the moment he was shot?
I personally was not there, so I cannot attest to specifically knowing exactly what Mr. Martin was doing at the time. I can only base my opinion on the totality of the evidence as I've learned it throughout my exploration of this case.
Which includes your perceptions, or his perceptions as he told them to you, right? Didn't you say the defendant's perception is important?
The perception of an individual involved in any conflict is what you have to take into consideration when making a forced decision. So the perceptions, if I told you I had a perception that the Jolly Green Giant was jumping on me, that would be ridiculous. But if I was in this booth right behind here and said I had the perception that one of these wires were wrapped around my ankle, it was plausible. The perception is taking in the totality of the event as it unfolded to see if the perception that was related by Mr. Zimmerman was plausible.
Right. The perception that was related by him.
Absolutely, yes, sir.
And your conversation with him came about 2 or 3 months before his second-degree murder trial, right?
Sure, that sounds about accurate, yes, sir.
You were asked about testifying. This isn't the only time you've ever worked in a criminal case, right, on behalf of a defendant, is it?
No, sir.
I mean, you've been consulted on plenty of cases on behalf of defendants, right?
You're going to have to qualify that a little bit more and say I've been a bunch of cases on behalf of the defendant.
Right. Have you ever been retained, hired by a defense attorney to testify or consult with on behalf of a criminal defendant?
A criminal defendant, I believe, retained. It's in my curriculum vitae, so I don't want to misspeak this. Twice, maybe, I think. One would have been, I think, the Chambers case, and the other one would have been where I consulted, did not have to testify either by deposition or in trial. The name of the gentleman's escaping me, but it's toward the bottom of my CV.
This is just the first time you've testified in front of a jury.
Yes, in a criminal case in this way, it is the first time I've done this, yes.
And you mentioned the continuum of force, the force continuum, that applies to law enforcement officers, right?
The force continuum is a conceptual model. It's when you look at use of force, if you looked at Florida state statute, that's a continuum. It's a systematic approach to the escalation and de-escalation of force. The use of the words continuum came out of law enforcement, yes, but the actual application of the concept is regardless whether you're in law enforcement, you're in the military, or you're an individual on the streets of, Orlando. A continuum is still part of the conceptual variables that you consider when looking at a use of force event.
You were asked about getting punched in the nose. You don't know when George Zimmerman was punched in the nose during this confrontation, do you?
No, he was punched obviously repeatedly during the event. The exact time that the injuries to the nose were sustained, I couldn't tell exactly.
And it may have not have been from a punch even, right? Didn't you say earlier it could have been when he hit it on something else?
No, I never said that. I never said that George Zimmerman hit his face on anything else.
Could it have been caused by something other than a punch?
In this event, I'm not aware of anything else that was present to have resulted in that injury. So
Okay, you're not aware of the concrete?
I do not believe that a facial contact of that nature with concrete without seeing other types of abrasions to the face and the eye areas, because when you're talking about the force significant enough to cause that damage to his nose with an impact on a flat, hard surface, you're going to have continued rollover, which is going to increase injuries in some area around the face. And it was pretty clear that the abrasions around the eyes or anything like that, so I wouldn't recommend the position that concrete caused that nose thing.
Well, let me ask you this. You've been punched in the nose before, right, during a fight?
Absolutely.
You didn't quit, did you?
I didn't quit?
Right. Did you keep fighting?
No, I'm a fighter.
So you kept fighting?
Absolutely. If you're a fighter, that's the whole purpose of entering into a fight is you fight.
And you've seen other people continue to fight after they've been hit in the nose, right?
I have seen both. I've seen people that when they've been struck, it exits the fight right there. The fight continues, but they are not able to respond in any form or fashion. and then I've seen others. And I mentioned earlier about the warrior mindset. Not everybody has that. So when you look at an individual, if they're involved in a physical altercation and they don't have that internal fire to be involved in that way, they're not going to fight. And when the fight starts, they're going to be that person that's just beaten. Where conversely, if you have somebody that's got the warrior mindset and they're struck, they're going to return in like fashion, and then you have two individuals with the same mindset going about one another, and you have tremendous damage to both persons because neither one of them is going to stop.
All right, my question was, have you seen people who have been hit in the nose during a fight and they keep fighting?
Yes.
Okay. Mr. O'Mara got on the floor here, and I got on the floor, and we did this little demonstration. You kept using your hands like this, like got to be 90 degrees, right? The two bodies, isn't that what you did?
I was trying, considering you were on the floor with a mannequin, I was trying to use my hands as trying to best relate that I could, that just being in this position, when you talk about 90 degrees, we're talking about maintaining a level or an alignment in some ways that puts them in a position. So when you talk about leaning back, maybe Mr. Zimmerman's coming up, but when you had the mannequin in that position, you weren't maintaining that same alignment, so the 90 degrees that you were referring to wasn't possible from what I was seeing. So I was trying to visually use to show that, you notice when one hand turns, the other hand turns. At some point, they were in this alignment that enabled them to have that type of entry wound.
Okay, well, in fairness, haven't we left something out? That is like the wrist and the hand and the arm. Can't that move independent of the body?
Sure,
Right?
but what you're talking about there is you're now wanting to say that it's this. Is that what you're saying?
Well, I'm asking you, if I'm laying flat on my back and somebody's over me like this, can I not shoot him at 90 degrees even though I'm on my back? Because
Can
my
you?
arm-
Yes, but when you also look at it from the perspective of actual discharging a firearm, if you try to hold any firearm and then hold like this to shoot, it's going to become much more complex. The average person isn't sitting there trying to do this, and they don't do it like you see in the movies where they hold it gangster style. The idea is when they draw a firearm, it's put to work in the manner in which it's drawn, which is by grip. So could he have taken the gun up and angled his wrist this way? Anything is possible. That doesn't make it plausible.
Okay, well, tell me then. Tell me what's not plausible about this. If I'm laying down on the ground and somebody's over me at any angle, I can always make it 90 degrees, right? I mean, it can be 90 degrees here, it can be 90 degrees here, it can be 90 degrees here. It depends where the other person is, right?
Everything depends on where you are in relation to that other person. It also depends on where the firearm is in relation to that other person. When you talk about the discharge of a firearm, and you talk about, and if you've done any kind of shooting, if anybody's done any kind of shooting, you learn very rapidly that the wrist position is not exaggerated. Why? Because that's not how you shoot. It takes very much conscious thought to remove yourself to put it so that you're out of another position. Is it plausible? It's possible that the wrist was moving, and I'm not trying to say it's not possible, it's just highly unlikely.
So it's possible you can shoot somebody almost at any angle because we have arms and wrists and elbows, right?
Anything is possible, yes.
You were asked a question, I think, before the lunch break about, was it your opinion that George Zimmerman's perception of the threat had disappeared because Trayvon had run off? Is that what you said?
Make sure I was very clear on this. When I listened to the call and I heard Mr. Zimmerman mentioning Mr. Martin in the recording where he was facing him, my perception of that call at that time, I sensed stress in his voice about the fact he was approaching him, looking at him, his hands was going toward his waistline. As he left, that tension diminished. That, to me, also reinforced what I've already heard from Mr. Pollack and saw from, again, reviewing the information in this case. He's not the confrontational one. He's not that I'm going to get on you type. When Mr. Martin ran, is what basically he's running, there's no immediate threat to him. His perception is he's taken off running, so he gets out, and that's where he is now trailing or following, I would say following the person, to see where they went because that's what he was doing for them.
Well, didn't you hear the defendant say, I don't want to give up my phone number because I don't know where he is?
Yes.
Doesn't that indicate to you that he still might be a little concerned about what's going on?
Mr. Zimmerman?
Yes.
Oh, absolutely. But I mean, when we look at it that way also, and we're talking about timelines, if we're thinking about the T, and he took off running to make it home, it's my understanding home wasn't that great a distance away, considering his age. How come he wasn't able to make it the exact distance? If he's still in the area, it's presenting a concern for Mr. Zimmerman because he's lost complete sight of him. He's not running at the end of his distance, even though the visual acuity is minimal because of the darkness. So now you're looking at an individual that is walking back and he's uncertain as to whether or not he's actually still there, so he doesn't want to give out his phone number.
Let me ask you one more question about the firearm. Were you aware that the defendant was trained by a federal marshal how to shoot?
Yes.
You also said that interviews, you feel like an interview is better if it's delayed.
Not all interviews. We were talking about the use of deadly force, and the comment was made to me about, for example, using references for law enforcement. It is a common practice to delay the interview because of the known memory loss issues and to extend the time before you conduct a thorough investigative interview of a police officer.
But that's not what you... Go ahead.
My interpretation when I was asked that question is it just seemed reasonable that if we extend that courtesy to law enforcement, it can be extended to anybody.
But that's not what you did as a police officer, right? I mean, when you arrested somebody, a suspect for a crime, you didn't wait a couple days to interview him, right? Didn't you interview him right there?
Of course not. Because the idea is, and I mean, to be very honest, when you're a police officer, you're told all the elements of the crime to the best of your knowledge. You're given the discretion to make a decision as to whether or not an arrest is warranted, and you base it off the facts that are known to you at the time. So when you ask for an interview and you're interviewing a bad guy, if it happens to be a homicide, which I have investigated homicides, if it happens to be a homicide, you're going to go in right away. And if the individual says, I want a lawyer, they're getting their period of time where they're not going to have to talk. That's their lawful right. The investigator doesn't wait. The investigator goes ahead in and tries to get whatever information he can, but he also uses the totality of the circumstances that he finds himself in so that he forms his questions and he makes a determination based on those interviews whether or not an arrest is warranted. But I wouldn't wait 3 days unless there's no rush to make the arrest.
And you're aware that the defendant spoke with his friend, the best friend that I've asked you about 8 hours after this event?
It's conceivable, yes.
And just to be sure, just to be certain, you're not an expert in memory retrieval. That's not what you're telling us.
Memory retrieval? No, sir.
Right.
No.
May I have just a moment, Your Honor? That's all I have, Your Honor. Thank you.
Thank you. Redirect.
Just on the new issue that was addressed, one issue. You had talked about this warrior mentality or warrior mindset.
Yes, sir.
Can you give the jury any insight based upon the evidence in this case as to whether or not Mr. Zimmerman evidenced a warrior mindset or not?
Based on the information I received from probably one of the most important persons I talked to with that regard was Mr. Pollock, the gym owner. And his description and everything about Mr. Zimmerman was not one to enter in the ring. He was not confrontational. Everything that I've reviewed in this case would indicate the opposite. He was not the type that had what we would refer to as a warrior mindset, that inner fire that compels you to be a fighter, that compels you to be that person that wants to get into the ring to test your skills against another person.
Was there anything about but for the gunshot, the lack of injuries on Mr. Martin that helped you with that decision?
Based on the injuries that we've all seen for Mr. Zimmerman and the lack of injuries on Mr. Martin, I would take that as evidence that he didn't have any striking. Even though he's on the ground and in this tussle, he did not do anything of any significance that would have been able to even result in an injury to a man. So that would support, again, the same information that I already derived from another source.
He didn't even land a strike, at least one that left a mark, did he?
Check that as call for speculation.
Sustained.
How about any evidence gathered from this event that suggested that Trayvon Martin did have a warrior mentality or mindset?
That is beyond the scope and in violation of the lending motion.
my response?
Sustained as to the violation.
The door was opened, Your Honor. It was this prosecutor that asked that very question. I'm just asking him to focus.
And you've already asked your questions about that, so I think that.
I'm now asking about Mr. Martin, not Mrs. Zimmerman any longer.
My objection, my ruling remains sustained.
Yes, Your Honor. Was there any evidence in the case that you've looked at that would suggest that even through the 45 seconds worth of screaming that the attack stopped?
Judge, I'm going to object to that as calling for speculation.
Well, he asked him if he was aware of any evidence overruled.
No, I saw nothing that would indicate that to me.
Thank you. Nothing further, Your Honor.
Okay, thank you. May Mr. Root be excused?
Subject to recall, Your Honor.
Okay, thank you very much, sir.
May we approach on the issue of recall for a moment? Just,
We can address that later, but I will tell him he's subject to being recalled. And then we'll address the issue about recalling later. You're excused from the courtroom today, but you're subject to being recalled. Please call your next witness.
just have a moment.
Yeah.
Thank you for the time, Your Honor.
Okay, thank you. Call your next witness.
Ms. Bertolone?
Do you solemnly swear or affirm that your testimony in these proceedings will be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you.
You may proceed.
Thank you. Good afternoon, ma'am. Could you state your name, please?
Olivia Bertolin,
Okay. And Bertolone, if you would spell that last name?
Bertalan.
And at one point, back in February of actually early 2012, did you live in the Retreat at Twin Lakes area?
Yes,
Have you since moved out?
yes, I have.
Okay. Are you married?
Yes, I am.
Do you have any children?
2,
Okay. And their ages?
2.5 and 4 months.
Okay. Going back then to when you still lived at Retreat View Circle, did an event happen at your residence where a crime was committed?
Yes.
If you would explain to the jury what happened with that.
I was home on a Wednesday with my son. He was, I think, 9 months at the time. And I heard someone ring my doorbell repeatedly. So I went to check upstairs because I didn't have a peephole. And I saw 2 young African-American guys ring my doorbell repeatedly, and they kept on looking up at the window. And I called my mom because I didn't know what to do. And they left. Then after a while, I went back upstairs to check one more time. And they were walking in front of my house. One came towards my house. And I was on the phone with my mom at the time, and I started crying. And I called the police. They broke into my house. I heard some bangs downstairs. The dispatcher told me to grab any weapon I had because I had my son in my arms. He had woken up, and just prepared to use it if I had to. The guy was I was locked in my son's bedroom, and he was shaking the doorknob trying to get in. And I was sitting there with a pair of rusty scissors and my son in one arm, and the police came and they ended up leaving.
And do you recall approximately when this happened?
August 3rd of 2011.
And did you then take a place of refuge or hiding while this was occurring?
Sorry, yes, I did.
And where did you go to hide?
My son's upstairs bedroom.
In the closet?
I wasn't in the closet. I was in the far corner because the closet was closer to the door. So she said to get away, as far away from the door as possible.
And did you have your son with you during that time?
Yes, I did.
Did the people who were downstairs at some point, did they leave the house?
Yeah, once,
Did
I
they-
guess they escaped before the cops got there.
And did they take any items with them?
Yes, they did.
What did they take?
My camera, our laptop, they tried to get our TV. It was unhooked, but he had it hooked up to our computer, so they couldn't get it off. I think there was something else, but I can't remember what it was, but definitely our camera and my laptop.
And at some point, then one of those people, or at least one of those people, were arrested and found and arrested and charged with that crime?
Yes.
And do you know what happened? Do you know the person's name?
His name is Emmanuel Burgess.
And is that the reason why you moved from that area?
Yes.
Nothing further.
Just for you, thanks. Ms. Berlin, good afternoon.
Good afternoon.
You had some contact with George Zimmerman after that event, did you not?
I did.
Okay, and
Direct, outside the scope of direct.
Judge, it's the basis of her testimony, I believe.
I would have to definitely proffer at the bench.
Well, we can't proffer to the bench. Ladies and gentlemen, if you'll please put your notepads face down on the chair and follow Deputy Jarvis out of the courtroom. Please be seated. You may do your proffer.
Ms. Berlin, I believe you said that this crime happened to you on August 3rd, 2011.
Yes, sir.
Did you have contact with George Zimmerman that day?
I did.
Okay, when I say George Zimmerman, I'm referring to the gentleman seated at the end of the table to my left.
Yes,
Correct?
Sir. Yes, sir.
All right. He came to your house,
Yes.
and he gave you his phone number.
Yes.
And the reason he came to your house, as he described to you, was that he had heard you had been a victim, right?
Yes, sir.
And you talked to him about it, correct?
Yes, sir.
You described the people that you saw at your residence.
I believe so.
You described them as two people as opposed to one,
Yes.
as males,
Yes.
as black,
African American, yes.
as teenagers.
Yes. I said they looked young.
And that wasn't the only conversation you had with this defendant about that case and you becoming a victim, right?
Right.
Is it correct to say that you and he talked about this approximately 20 times after that?
Probably around there.
I'm sorry?
Probably around that amount.
And you discussed with him the fact that the person had not yet been caught?
I'm sure I did. I spoke to several people about it.
And the person wasn't caught until after you moved out of the retreat at Twin Lakes, right?
He was arrested in December. Then he was released because he was a minor, and he was arrested again after we moved out.
After you moved out.
I believe so. We got a letter after we moved out. I'm not sure the exact date of his arrest.
And another thing that you and George Zimmerman discussed was where you believed or he believed that particular suspect lived, right?
I'm sure we discussed that.
And you discussed that he lived near the back entrance of the retreat at Twin Lakes?
Yes.
Your Honor, I have other questions for, but they don't relate to her contact with the defendant.
Okay.
So that would be the extent of the proffer, I believe was what was objected to.
I withdraw my objection.
Okay, thank you. Let's go ahead and bring the jury back. Please be seated. You may continue.
Thank you, Your Honor. Ms. Berlin, I believe you said this incident happened to you on August 3rd, 2011.
Yes, sir.
Okay. That day, did you get a visit from a man named George Zimmerman?
I did.
All right, and is he the gentleman seated to my left at the end of the table?
Yes.
Used to live in your neighborhood, right? He used to live in your neighborhood.
Oh, sorry. Yes.
And he actually came to your house that day, correct?
Correct.
I need you to just speak out
Sorry.
loud. And he talked to you. The reason he came to your house, he didn't know you, right?
Right.
He came to you because you had been a victim of something, right?
Yes.
And you described for him what had happened to you that afternoon.
Yes.
And you described to him the people that had victimized you, right?
Yes.
And you described the number of people.
Yeah.
How many did you tell him?
2.
And did you describe the sex of the people?
Yes.
And what was that?
Male.
Did you describe the race of the people?
Yes.
What was that?
African American.
Did you describe the age of the people?
I didn't know the age for sure, but I'm sure I told him I assumed they were late teens. They looked that age.
And after that, you and he continued to talk about that very case, right?
Mm-hmm.
Yes?
Yes.
Okay, approximately 20 times. Is that fair?
Yeah.
And you and he discussed that the person or persons involved had not been caught, right?
Right.
And you discussed that it was your belief, and I say your collectively, you and him, that that person responsible or one of the people actually lived in the retreat at Twin Lakes, right?
It was confirmed by the police.
That they
So-
lived inside.
Yes.
And you discussed that with the defendant.
And other neighbors.
And you discussed that that person lived in retreat at Twin Lakes near the back gate, right?
Yes.
And then it's your understanding that at some point that person was arrested
Yes.
and released prior to February of 2012.
Correct.
You have you watched the proceedings in this trial?
Briefly.
What parts did you watch?
I believe I saw his uncle testify.
Who else?
I don't know any by names. I haven't watched very much.
Have you tweeted about this case?
Not since. No, I have not.
Not since what?
Maybe last year when it first happened.
You haven't tweeted about this trial
I don't believe so.
this week?
I don't believe so.
You do have a Twitter account, correct?
Yes.
And you follow. You actually follow Mr. O'Mara, do you not?
Yes.
And you follow an account or a site called Zimmerman Legal Case, right?
I do.
And you have been on Nancy Grace
Yes.
in regards to this case.
Over a year ago, yes.
Have just a moment, Your Honor. Ms. Berlin, thank you for your time.
Redirect.
Thank you. Just a few follow-up questions, ma'am. When Mr. Zimmerman came to you to talk to you about having been victimized by a home invasion, did you consider that strange?
No.
Were you appreciative of his efforts to help you out?
Very.
Tell me about that.
We were terrified when this happened, and when we came home after we were having car troubles, and we came home, and he was just saying that he wanted to make sure we were okay. We weren't home. My sister was, and she didn't answer the door because she was scared because of what had gone on. So I was just appreciative that he was offering his hand and had told me I could spend time with his wife if I needed to go somewhere during the day because I was so afraid.
He told you that his wife Shelley was a nursing student, correct?
Correct.
No objection as to hearsay.
Did he tell you, what did he tell you about his availability, if any, of his wife to be there for you if need be?
There's objection to that as to hearsay and relevance.
It's,
Well, I'm really having a problem with the relevance.
I was just following up, but, okay, Your Honor, I'll just focus it again. Were you aware that Ms. Zimmerman was there for you as well, if need be?
Yes, sir.
Did you then at some point, shortly thereafter, go to the homeowners association and discuss the issue of the home invasion?
I don't believe I went. My husband did.
And then, in addition to your conversation with George Zimmerman, did you talk to other people about what happened to you?
Yes.
Who's that?
A couple of my neighbors, a neighbor named Pete, another neighbor, Chris.
Was this home invasion then something of a point of conversation because of the trauma that you had with it?
Yes.
Matter of fact, did Mr. Zimmerman, after the homeowners association that started Neighborhood Watch, did he bring to you a lock to help you with the sliding glass door?
Yes, he did.
Did you consider that weird or unusual or strange?
No, I was very appreciative.
Were you made aware that there was a issue with problems with the sliding glass doors in your neighborhood?
I don't believe so.
Was it actually how they got in the house, a sliding glass door? Or another?
Yes.
So they actually came in through the back sliding glass door?
Mm-hmm.
Did
Yes.
this lock then help secure that problem?
Yes, it sits behind it, and it locks it tight so they can't pull it open.
And before you moved out, you even had, didn't you get a dog to help?
Yes, we did.
Was that part of trying to just stay more secure in a neighborhood where you've been burglarized or invaded?
Yes, the cops told us to get a dog.
You know the person who was arrested was Emmanuel Burgess, you said,
Yes.
and that he was released?
Yes.
Did you know that he was rearrested on February 6th of 2012?
I didn't know when. I got a letter after we moved out, so I didn't know exactly when he was arrested.
Did any of your interactions with Mr. Zimmerman in this regard leave you with some impression that he was just too involved in trying to help you out?
No,
Did you think that his behavior was helpful to you?
very.
Still have the dog?
Yes.
Thanks very much. Nothing further. Your Honor.
Thank you. May Ms. Bertolone be excused?
She may.
Yes, Your
Thank you very much. You're excused. Please call your next witness.
Honor. Defense would call Robert Zimmerman Sr., Your Honor.
Do you solemnly swear or affirm that your testimony in these proceedings will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you.
Remain quiet.
Thank you, Your Honor. Good afternoon, sir. State your name, please.
Robert Zimmerman.
And live here in Central Florida, correct?
Yes, sir.
How long have you lived in Central Florida?
Almost 7 years.
You know George Zimmerman as your son, I imagine?
Yes, sir.
Okay. Understand, of course, he's here on a second-degree murder charge, right?
Yes, sir.
going to limit my questions to you to an event where you had an opportunity to hear what we have been calling a 911 tape, or Miss Lauer's 911 call. Do you know what I mean when I ask you about that?
Yes, I do.
It is a tape that includes in it some screams and a gunshot. Have you
Yes.
heard that tape?
Yes, I have.
We have it available. The jury has heard it dozens of times now. I'll only play for you if you need it to hear it again, but do you have a memory of it such that you remember listening to it and forming an opinion as to who you heard?
Yes, sir, I do.
If you would just tell me the setting or the circumstances around the first time that you heard it.
I believe the first time I heard it, it was on the third floor of this building. It was in the state attorney's office. I was there. I was put under oath. They asked me some questions. As I was getting ready to leave, they asked me if I would mind listening to this tape. I said, certainly. So they took me in a fairly small room where there was a computer. They provided me headphones, and they reminded me I was still under oath and would I listen to it. I said, yes. So I listened to it. And then they asked me, did I recognize the voice?
And what did you tell them?
I told them, absolutely, it's my son George.
Is that an opinion that you still have through today?
Certainly.
Nothing further on.
Thank you, Cross.
Good afternoon, sir.
Hi, sir.
I think you've listened to it 6 times, is that correct?
I'm sorry?
I think you've listened to that recording 6 times, correct?
No,
You have not?
no.
Okay. I may have a moment, Judge.
Yes, you may.
I've listened to it a number of times. I have no idea if it's 6 or,
Oh, okay.
I would probably say at least 6, but
More than 6 times?
I would
least-
guess at least 6, but
Okay.
I really
Thank you very much.
can't
sir.
be accurate.
Thank you, sir.
Okay, any redirect?
No, thank you, Your Honor.
May Mr. Zimmerman be excused?
Yes, Your Honor.
Subject to recall, Your Honor.
Okay, thank you. You're excused from the courtroom, subject to being recalled, sir. Thank you. Call your next witness.
I think this might be a good time for a break, if I might, Your Honor.
Okay, ladies and gentlemen, we'll take a 15-minute recess. If you'll please put your notepads face down on the chair and follow Deputy Jarvis back into the jury room. Please be seated. Is the defense going to be calling any other witnesses?
No, Your Honor.
Okay, so after the recess, I'm going to ask Mr. Zimmerman about whether or not he wants to testify. But at this time, Mr. Zimmerman, were there any other witnesses that you wanted your attorneys to call on your behalf, sir,
No, Your Honor.
Okay.
For this hearing?
for this trial?
Oh, the trial.
You've been here through the trial, and we've had, we've had 40 witnesses that were called by the state and 19 witnesses called by the defense. Some of them were called, I'm sorry, I'm talking to Mr. Zimmerman. Okay, some of them were called a couple of times, such as Ms. Singleton, so it's really less than 19. My question to you is, Mr. Zimmerman, were there any other witnesses that you wanted your attorneys to call on your behalf at this trial?
No, Your Honor.
Okay, thank you very much. When we get finished with the recess, I'm going to ask you about whether or not you're going to testify.
Yes,
So
ma'am.
take the time you need to talk to your lawyers.
Thank you.
Okay, thank you very much. Court will be in recess. Please be seated.
As we have a moment before the jury comes in, there are a number of exhibits that we have put in by stipulation. So they're now in evidence. I don't think that the court needs to address those. Since we are on the verge of closing, there's one composite exhibit that the state is going to just review momentarily and then not have an objection. That will be the last one that's going to be entered in by stipulation.
So that would be composite exhibit 30?
Yes, actually, yes. It's only one document. It's just 7 feet long. And it's a composite.
Okay. What is it?
It is a timeline.
Okay, defense timeline. Okay, Mr.
Your Honor, we just want to verify some of the times on there, and it took us a little while, but
Sure.
I'm told, other than that, we won't have an objection, assuming it's accurate. I'm not saying that it isn't, we just want to be able to have some time to verify that.
There are only two other slightly loose end. I'm sorry.
Whoever wants to speak first.
Go ahead.
Go ahead. No. Go ahead.
While you're out, the items that we stipulated to, they hadn't been marked, and those items contained item 30, so we were already up to item 30. The next one would have been 39 for the timeline.
Oh, okay.
I'm sorry. I don't understand what you just said.
They hadn't been marked them for exhibits, and then they stipulated to them to be entered into evidence. We hadn't marked them for evidence. So I marked them items 30 through 38.
Okay. I don't understand what you're saying they are, because what Mr. O'Mara showed me is
All
a
of these
long
defense.
line.
I'm sorry, if I might. These are now in evidence as 30 through 38.
Okay,
And we'll identify those for your list. You want me to go through them?
I do.
Okay.
30 being,
Give me,
Your slide.
okay.
It's going to be on the bottom.
All right, I'll take care of them. 30, Your Honor, is a picture of the back of Mr. Zimmerman's head.
31.
31 is the front of Mr. Zimmerman's head.
Okay.
32 is still photograph of Mr. Martin in 7-Eleven. 33, a picture of Mr. Martin's pants. 34, a second still of Mr. Martin at the 7-Eleven. 35, a aerial view of the retreat at Twin Lakes, area of inquiry. 36 is a larger aerial photograph of the entire area of that portion of Sanford. 37 is a large aerial of retreat at Twin Lakes. And then 38 is a medical ME investigator's picture of the scene. Then if admitted, then 39 would be the timeline we talked about. There are two other loose ends. One is what we talked about with the judicial notice of the weather. We came up with a more accurate one for the 26th. That's going to be substituted, and that's close to me but not in my hands. And I'll get that to you as soon as I can.
Is that stipulated as the substitution for State's Exhibit 213?
Yes.
Okay, so as soon as you get it, Trish, will you allow that to be substituted for the one you have?
And the
Right.
next one would be the same exact type of exhibit for the 27th of February.
That's correct, Your Honor.
Do you want that as composite at State's 213, or do you want the other one?
We planned them as separate so that we would not mess up the clerk, so the
Okay.
substitution would be for the
So
26th.
we'll substitute 213 for the new one, and we'll make the second one for the February 27th, Defense Exhibit 40.
Yes, Your Honor. And the- Yeah, I'll do that. And, Your Honor, the only other one was that there is an exhibit that, in order to move matters along when Ms. Gentile was being questioned, we used a very small portion of the CD to question her. And we acknowledged to the court that we would present to the court that as its own, just redaction of its own one portion of it. So that hasn't been brought into evidence yet. That needs to be presented as well because we used that, if you might recall, to refresh her recollection as to what she said, but we used the entire interview of her, which would not be appropriate to go back to the jury, just the one portion that was played. And we're going to get you that CD, and that's the last matter.
My recollection is she was just able to either listen to it or something, but not in front of the jury.
It wasn't played in front
I
of the
don't think it
jury.
was. I think
The
it
jury was sent out.
Yeah.
And I said, since it was an impeachment, so it wasn't played in front of the jury.
I might just have a moment, Your Honor.
Yes, you may.
Just to be clear, my understanding was that the part that, and I may just be wrong and I apologize, I understand that the part that was played was the portion of it that's where she said that could be Trayvon, that might be Trayvon, and those words, and I believe the jury was present.
Okay, they weren't, but let's do, if we could get the court reporter's notes from the date that Ms. Gentile testified. It was 2 different dates. I believe, is it Defense Exhibit Double D? Is that how it was identified? Because I have that as a tape of Gentile interview with the state attorney's office.
I believe it was, Your Honor.
Is that
Yeah,
DD?
Yes,
It was
and I
not
think-
played in front of the jury, but we can verify it. Is there any way to get? Okay.
Tell you what, it looks as though there may be an issue. We will have some time between now and the time the jury would get it. We'll take care of fixing it and
Okay.
letting you know. The only concern was that this is now in evidence as DD, and this is...
Not in evidence, it's
Oh, I'm
identified.
sorry. So this is just marked, I apologize.
It's marked for identification purposes. Okay, were there any more of those house,
The state has to look at it to confirm, and we'll be in
any more housekeeping matters?
We'll get you the weather information. I think that's it, Your Honor.
Okay, Mr. Zimmerman, please stand up. I'll remind you, sir, that you're still under oath from when we had you sworn in earlier before the break. Did you now have sufficient time to discuss with your attorneys whether or not you wanted to testify in this case?
Yes, Your Honor.
And I don't need to know what was said, but after those discussions, have you made a decision?
Yes, Your Honor.
And what is your decision, sir?
After consulting with counsel, not to testify, Your Honor.
Okay, you understand that no matter what counsel says to you, it's still your decision. Do you understand that?
Yes, Your Honor.
Okay, and I need to know, is it your decision to not testify in this case?
Yes, Your Honor.
And are you making that decision freely and voluntarily?
Yes, Your Honor.
Has anybody promised you anything to get you to make that decision?
No, Your Honor.
Has anybody threatened you?
No, Your Honor.
And this is clearly the decision that you yourself have made.
Yes, Your Honor.
Thank you very much. Is the defense going to rest subject to any more evidence being entered? And
That's correct, Your Honor. Thank you.
is the state going to have rebuttal evidence? Testimony?
Yes, Your Honor.
And how many witnesses are you going to be calling for rebuttal?
Have at least 2 today, and one who is not available today should be available tomorrow, which we may not end up calling anyway.
Okay, I still haven't seen the proposed jury instructions. It's my understanding that a copy has been provided to the defense and a copy has been provided to Mr. Zimmerman. Is that correct, sir?
Yes, Your Honor.
Okay. Can I please have a copy? Are these 2 witnesses going to be lengthy?
I don't think so, Your Honor.
Can we do a charge conference after we excuse the jury for the day?
I don't see a reason we can't.
We can start. We have some special jury instructions to prepare and present, but we can at least get a feel. I think might now be the time for me to renew my judgment of
Right,
acquittal.
and then you'll rest in front of the jury and we'll go forward.
Yes.
Okay, you may proceed. Yes, I'm sorry, yes.
No, I think with the length of the presentation to you earlier, I'm going to certainly abbreviate and not readdress the arguments nor the case law that I address. I would certainly ask you to reconsider those. I think that the factual basis, however, has changed somewhat, and I'm not going to recount it because I know that you were sitting here along with us during the whole time of hearing it, but that the defense case has presented now evidence that I believe, uncontroverted evidence, that supports my client's contention that he acted in self-defense. That includes, of course, the most recent witness, Mr. Root. It includes Dr. DeMaio and his expert testimony in regard to the gunshot, and also the other information concerning the injuries that my client suffered. We also have a number of voice witnesses, if you will, those witnesses who have come back and testified before this court that they had no issue whatsoever and were quite firm in their position and belief and testimony under oath that it was my client who was screaming for help. And again, I don't want to belabor the point of the previous case law, but I think that you would need to decide at this point basically that there is that the state has excluded at this point in the trial a reasonable hypothesis of my client's innocent, and now with the strength of the defense presentation that they have failed to do so, and I would ask that the charges be dismissed in full.
Response?
Thank you, Your Honor. If anything, the state's position is that Dr. DeMaio certainly portrayed at least one alternative scenario where the defendant could absolutely have committed second-degree murder against Trayvon Martin, just by virtue of his answer to Mr. Delarianda's questions, that being that Mr. Martin was attempting to pull back or disengage when he was shot and murdered by this defendant. Moreover, to say that Mr. Root's testimony was uncontroverted is, I think, overstretching it even more than Mr. Root did. Certainly he was very eager to draw conclusions, but he also had to admit finally that he had absolutely no idea what exactly went on at the moment that this defendant shot and killed Trayvon Martin. So we believe that while the defense may have presented people to sort of enhance the dispute of facts and the inferences that can be arisen, in other words, to make it perhaps even more disputed, that the state has certainly submitted sufficient evidence and will again continue to do so in rebuttal to indicate that both the facts and the inferences that can be drawn therefrom would support a jury verdict as to both murder and the lesser included manslaughter.
Very brief response. I would just ask that either the state or perhaps the court, if you're going to rule, come up or identify the state's factual scenario, their theory of the case, anything for which there is that excludes a reasonable hypothesis of innocence of my client now that they finished their case and we've finished our case. I would ask that that be articulated in some form or fashion either by the state so that you can make the ruling or by the court in your ruling that actually suggests that legally this judgment of acquittal should not be granted.
Okay, thank you. The court has sat here and listened to all the witnesses. I think I have previously said how many witnesses had testified both on behalf of the state and the defense, and have listened to the arguments both at the end of the close of the state's case and now at the close of the defense case. And the court's decision is the same, that there is substantial evidence, both direct and circumstantial to allow this charge to go to the jury. So we need to bring the jury back in. You need to rest in front of the jury, and the state be prepared to call your first rebuttal witness. Let's go. Are we ready to bring the jury in?
Is there a chance of finding out who the rebuttal witnesses are so we can see if there's discovery issues or
Yes,
whatever?
and then we have to, at some point in time, deal with the Mr. Donnelly issue. We could do that after we've talked about it. Who's the witness that you're going to call next?
First one will be Adam Pollock.
Right, and can you tell us who the second one is going to be?
David Lee.
David?
Lee.
Thank you.
Okay, they had a third. I just didn't know.
They didn't know if they were going to call that person tomorrow or
I
not.
have to ascertain his certain availability, Your Honor. I just haven't.
When you find out tonight, would you please email the defense and let them know so they could be prepared for that in the morning?
Yes, Your Honor.
Thank
And I
you.
know the state understands that they are bound in true rebuttal. Mr. Pollock testified before. I want to make certain this is not just a re-examination of him, but it is truly in rebuttal to some particular fact that we presented in our case.
If it's not, you're free to object, and then I'll roll.
Yes, Your Honor.
Are we ready to bring the jury in?
The defense is ruling.
Yes, sir.
Okay, you need to again rest on the record.
I will do that.
In front of the jury, I mean. Please bring the jury in.
And that will just take my announcement, correct?
Yes.
Thank you.
Please be seated. Mr. O'Mara?
Yes, if I might, just to announce to the jury that there was a number of other exhibits put into evidence. Not going to go through them all, just to identify them, because we'll be talking to them about it in closing, but a number of photographs, I believe it's number 30 through 38, and there's potential of a 39.
Yes.
And then some other judicial notice matters concerning weather that we'll address with the court. But with all that in mind and now being entered into evidence, the defense would rest.
Thank you very much. Does the state have any rebuttal?
Yes, Your Honor. Call Adam Pollock.
Yes, it's a different day. Thank you for asking.
Raise your hand, please. Do you solemnly swear affirm that your testimony in these proceedings will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
You may inquire.
Thank you, Your Honor. Mr. Pollock, just to remind the jury, you were the defendant's trainer at Cocapelli's Gym, is that right?
Yes, sir.
And are you now marketing the training that you gave to George Zimmerman on your website?
I'm sorry?
Are you now marketing the training that you gave to George Zimmerman on your website?
Absolutely not.
No?
What's actually going
Let me
on that?
object, Your Honor, if I might. That is improper rebuttal testimony, seemingly impeachment.
Okay, well, we need to have argument about that. Approach the bench. Continue this matter outside the presence of the jury. I'm sorry about that, but if you'll please put your notepads face down, follow the deputy back into the jury room. Please be seated. Mr. Pollock, you're still on the witness stand. We're taking a 15-minute recess here not to discuss this case with anybody, including the lawyers. And if you'll please wait outside, we'll be with you when we reconvene. Thank you very much. Court is in recess for 15 minutes. Okay, Mr. Manti?
You asked for additional potential citations to authority, Your Honor. I would tender one, McKee, M-C-K-E-E versus State. That is 712, 2nd, 837. Generally standing for the proposition that evidence relevant to a witness's possible bias, prejudice, motive, or intent is nearly always necessary to inform the jury of any motives regarding, in this case it was a prosecution witness, but I think it applies equally. So again, in addition to the Britton case that I cited, the evidence would be admissible for that purpose.
But what about the rule, the evidentiary rule that you can't call a witness for the purpose of impeaching?
Well, I'm not necessarily calling him to impeach him, because impeachment would mean that I am contradicting some of his earlier testimony. I am perhaps calling him to impeach the testimony of Mr. Root, but that's not calling him to impeach this witness. If this witness denies or says something that is contradicted by the actual written record, then it may be necessary to impeach him, but I don't think he's going to deny that that's on his website. He may offer an explanation. That wouldn't be calling.
What is within the website that would contradict any evidence offered by Mr. Root?
Well, I don't know that, as far as contradicting, he said that I believe he characterized Mr. Pollock as uninterested or unbiased or one of those, that characterization, I forget the exact word he used, but that he placed extra weight on his consultation for that reason. So it would not necessarily just contradict. I think it's also either contradict or help explain.
Okay, defense.
It has to, if it's impeachment, it's impeachment, and it has to impeach something. So let's talk about what it's being presented for. And we read from the same Bible, so I looked at Earhart for some insight on this, and what he says is that it actually has to be relevant. It has to truly impeach or address an issue of bias. In effect, if what we're looking at is this witness's, Mr. Pollock's bias and how he may have presented in a way that evidences his own personal financial interest, which I guess is the underlying request of the state, that they impeach or make believe not impeach, but impeach this witness by saying, you might be trying to make money on Mr. Zimmerman because he came to your gym. Let's just think this through for a second, and I think the court has to include within its context of authority common sense. So let's look at it through common sense filter for a moment. This witness who wants to tell somebody to come to his gym because I trained Mr. Zimmerman got in front of this witness, in front of this jury, and under oath said he went from a 0.5 a year when he first got to me to maybe a 0.1, that he was soft then and he's soft now. There's no financial interest that this witness furthered by his testimony, and that's why it's sort of bizarro impeachment, because it doesn't impeach what it would normally impeach. If this witness came in and said, this guy is great, and because of my training, he can kick anybody's butt, then maybe I would come in and say, wait a minute, aren't you making money by saying that you do a great job? We don't have that. We have the opposite of that.
Okay, what we have here and what the state had cited to the court was Britain versus State, 414 Southern 2nd, 638, and it is a 5th District Court of Appeal case. And in that case, the state didn't call this witness in their case in chief and called him in their rebuttal. And the court indicates that rebuttal evidence explains or contradicts material evidence offered by a defendant. And the testimony delivered by the state's rebuttal witness was neither explained nor contradicted any evidence offered by the defendant in that case. Permitting the testimony, however, was not error because the court has discretion in the order of presentation. What you're trying to do with Mr. Pollock is not an order of presentation. It is to impeach your own witness. You're calling him as a witness to impeach him by saying that he's advertising on a website about the Zimmerman trial and the Zimmerman training that he received at the gym. I don't think that that's allowed, and I'm going to sustain the objection.
Very well, Your Honor.
So I don't know how you want to handle this in front of the jury. We could tell them that Mr. Pollock is not going to be testifying, and you could call your next witness. Or we could have him come on here if you have any other questions that you wanted to ask him. This was the sole purpose?
Yes, Your Honor. I was going to call him and ask him about that particular website advertisement.
All right. Well, then the state agrees based upon the court's ruling. There's no reason to have Mr. Pollock come back into the courtroom?
Yes, Your Honor.
All right.
The next witness similarly has some objections to the presentation. We may as well take that up before the jury comes back in, if we could.
All right, and the next witness's name is, please?
Is Mr. David Lee, Your Honor?
All right, and what is the purpose for calling Mr. Lee?
Judge, could I have just a moment?
Yes, you may.
Mr. Pollock is going to be released from his...
Yes, Mr. Pollock will be released.
Judge, on balance, the state is not going to be calling Mr. Lee.
Right, and how about the other witness that the state was going to check on for tomorrow?
I haven't left the courtroom to be able to check on that, Your Honor. I haven't yet known.
Surprisingly, we have an objection to the presentation of that evidence as well, maybe to address it.
Maybe we can, Crawford, what is the name of that witness?
He is Mr. Fleischman, Your Honor.
And his first name?
I believe it's Arthur.
Arthur? And what is the objection to that?
Who is it?
He is the agent with the Bureau of Alcohol, Beverage, and Tobacco for whom the defendant was arrested for committing a battery on a law enforcement officer. That is who he is.
Okay, and the purpose for calling him?
Because the defense has gone to great lengths to assert that the defendant is, despite all the other circumstances, largely incapable of fighting. I think this agent would offer a different perspective on that, where he be permitted to testify. Specifically, he would essentially say that while he and some of his fellow law enforcement officers were engaged in arresting some persons at a bar at which the defendant was, that they had the individuals outside subject to being arrested, and the defendant came out. One of them, or at least one of the people being arrested, was one of the defendant's friends. The this agent in particular will say that he identified himself to the defendant, showed him his badge and identification, told him that he needed to leave while they were effecting the arrest of these individuals, and the defendant actually attacked him. That would be his testimony.
My response, Your Honor? One, it's a prior bad act that the state is trying to get in improperly, firstly. Secondly, of course, there's a 403 analysis that needs to be done by this court. Thirdly, you need to probably know a bit more about the facts of the case just so you can address it. The agents were undercover at a location out by UCF and had taken a friend of Mr. Zimmerman's out bodily because
Can I have a time frame in this, please?
It is 2005, Your Honor, so we're talking 8 years ago. Before, just so the court's aware, before he wanted to become a prosecutor, before he got his concealed weapons permit, where they did a background check, before he did the ride-along with Sanford Police Department. The reason why all of that was probably able to be accomplished by Mr. Zimmerman was that in 2005, when these agents grabbed his friend, who seemed to be underage, dragged him outside, and I think they'll probably acknowledge that that's how they accomplished it. Mr. Zimmerman, since they were in plain clothes, I think the officers will say that at some point they brought out their lanyards, but I think this court, previous court, Judge Lester, when he addressed this very same issue, I think opined succinctly that the way that these things are handled out by UCF is that the agents go in there sort of, I don't know if he used the word Gestapo, but something like that. Anyway, so they take him outside. Mr. Zimmerman goes outside to ask exactly what transpired. The officers didn't like the idea that someone was getting them in their way of what they thought that they were doing properly. And they arrested Mr. Zimmerman. I never heard that they said that he attacked him. I don't think that's in the police report. Maybe Mr. Manti can proffer the police report to the court. But in any case, he was arrested for battery on a law enforcement officer. That went to the state attorney's office, who dropped it down immediately to a misdemeanor, which you know from your experience they hardly ever do on true police victim crimes. They just don't do it, and they're told not to. Not only did it drop down from the charge to a misdemeanor, but then also opposed to the normal procedure of a case like this, it went into pretrial diversion. Having gone into pretrial diversion, he successfully completed that. They dropped the charges completely. So 8 years ago, he was in fact over-arrested for something. The initial prosecutor to review it identified it as being an overcharge, dropped it down to misdemeanor, pretrial diversion, and it was dismissed outright. It bears no significant probative value, both because it's ancient in time, it's ancient in act, and the way it was handled by the system suggests that it was a non-event even to begin with. I want to make sure that we're clear, however, that if in fact the state brings in this one prior bad act, suggesting that my client is now a fighter or something, that the very witnesses that the state attorney's office has relied on throughout this case particularly those interviewed by the Florida Department of Law Enforcement, and most particularly the Federal Bureau of Investigation, when they did their "Are you a racist?" interview of everybody who my client talked to, including family members, a lot of people from Retreat.
Okay, can you get to your point?
The point is that there are probably 30 witnesses to counter this one witness that my client is peaceful, nonviolent, friendly, mellow, and everything else. Information the state, and the reason why I present it now, information the state is well aware
I told you
of.
when we're at the bench, I really don't like these, you do this, I'm going to do this argument. Everybody, each side is available to present whatever case that they want to present within the bounds of the law and the rules of evidence, and they do so at their own peril for opening any doors that may be available. So I don't, you all are experienced lawyers, and you know what you can and cannot do, or should and should not do. So I don't want to hear, if you do this, I'm doing that. That will be based upon a ruling from the court as to whether or not any particular door has been opened from either side. Mr. Manti, you have indicated that you don't even know if this witness is available. We now know what information you seek to elicit from this witness, and we can have argument if he is in fact available and you're seeking to have him testify. We can have argument before he testifies. Are there any other rebuttal witnesses that the state would be seeking to call?
No, Your Honor.
Right. Based upon that, I don't know if you're going to have any rebuttal, so we'll wait to see whether or not.
There's been no rebuttal. I don't think it's appropriate.
Well, I don't know whether or not.
If you allow this, I'm sorry.
Right. So we'll take that issue up tomorrow. I would like to then inform the jury as to where we're going in this case. So there will either be some more testimony in the morning. We'll do our jury instructions tonight, finish them up in the morning, and I'd like to tell them that we're going to start closing arguments tomorrow. How long does each side anticipate that they will take in closing?
Since we have opening and closing in terms of, I would say 3 hours.
I presume that only one attorney will be handling closing for the state, correct, as per your normal course?
Well, I think in any other times that we allow another attorney to do the rebuttal, I've always done it that way, so if that's how they choose to do that.
I object.
Okay. Your objection is overruled.
I think 3 hours is certainly enough.
Are there going to be a lot of conversations or rulings having to be made by the court concerning the jury instructions, other than what we do with a self-defense instruction in light of the Supreme Court's review of that instruction?
There's that. There's an addition based upon a case that I've just mentioned to the state, but can present to the court as well, as Gibbs versus State, which is a slight modification to the self-defense instruction to identify a word that's not otherwise defined. I'll tell you now, I'll tell you when we get together. Then there is a circumstantial evidence one that I think that has certainly been presented to the jury as an existing element for them to consider. And
when do you anticipate having your proposed instructions to both the state and the court?
I told him I'd get it to him tonight, so I'll get him the case law and those are the two instructions. We have some argument on the inapplicability of manslaughter to the facts of this case. I'd like to argue that with you at some point. I think those are the three main, with consultation with Mr. West and my client. There may be a couple of other polishings, but I think that's the
How
focus.
long do you think that argument is going to take on the jury instructions? I'm just trying to get
Sure.
a feel for time.
Oh, I think half an hour. I mean, I think it's pretty straightforward. Circumstantial evidence is what it is. I think it's discretionary with the court, but when the facts support it, it's allowable, so I'm not going to retrain anyone on that. The Gibbs case just defines provoked because it's not otherwise defined.
Okay, and if you're not ready to present that to the state yet, I'd rather wait for the argument. I'm just trying to get a scheduling idea right now. If I were to release the jury to recess for the evening and bring them back at 10 in the morning, The state can start their 2 hours, if there's not going to be any further rebuttal, can start their 2 hours portion of their closing statement. They could go to lunch. The defense can do their 3 hours, and the state can do their hour rebuttal, and we can get it to the jury by tomorrow evening or have them recess for the evening and come back Friday morning. I'm going to leave it up to them as to how long they would like to do that for. So
Is now an opportunity, maybe after the jury's
we
released,
need to do the Donnelly hearing also.
to Donnelly, and also to address the issue of their rebuttal? And the reason why I suggest that now rather than tomorrow is, if you allow that, we may well have, I don't want to use the quid pro quo argument to you, but that's going to take a lot of work to get rebuttal witnesses together, a great deal of work, including all the other witnesses to that event and the other
Well, none of
things.
this may even occur if that witness is not available. Is there any way that you can let this court know sometime soon whether that witness is available at all?
Yes, Your Honor, I'm trying to check now, actually.
It may be a non-issue.
Okay, then we'll wait and see if we need to have the argument, I guess. Okay.
Let's go ahead and bring the jury in, and I'll excuse them for the day, and then we'll begin on Donnelly. Go from there.
Before they come in, you are also then going to address the argument of whether or not that door has been opened before they begin their rebuttal, and whether or not it's appropriate? I just want to make sure that's not waived. They sort of-
Nothing has been waived. I just want to know the availability of that witness because none of it may be an issue.
Yes, Your Honor. You should the court's clear as to coming in. We did file the judicial notices on the pleadings and exhibits. They're in.
I need to make sure that you need.
Please be seated.
Please,
Ladies and gentlemen, again, we have some more work that we need to do outside your presence, and instead of keeping you back there in the jury room, I'm going to let you recess for the evening. I just wanted to tell you the state of where we are. I hate to ever tell anybody what I anticipate will happen, because as soon as I say it, something else occurs. But we do anticipate to go to closing statements tomorrow. And since there'll be some more work that we would have to do in the morning, I'm going to have you come back at 10 a.m. So it gives you a little bit more time in the morning. When I have you recess for the evening, I want to give you the instructions. During the overnight recess, you're not to read or listen to any radio, television, or newspaper reports about the case. You're not to discuss the case amongst yourselves nor with anybody else. You're not to use any type of an electronic device to get on the internet to do independent research about the case, people, places, things, or terminology. And you're not to read or create any emails, text messages, tweets, social networking pages, or blogs about the case. Do I have your assurances that you will abide by these instructions? With that, put your notepads down, follow Deputy Jarvis, and have a good evening. Please be seated. What's been handed to me as State's Exhibit 213 is that the correct
That's the
exhibit.
replacement, Your Honor.
Okay,
to-
both sides agree? And then I've been handed Defendant's Exhibit 40, which is the weather report for February 27th. Both sides agree?
Yes, Your Honor.
Then you are going to look at Defense Exhibit 39, is there any objections to that,
Judge,
Trish?
they emailed it to me a few minutes ago. We're verifying it, so there shouldn't be, but I just want to verify it. So it may take a little bit longer because they revised it and we just need to check.
All right. Are we ready to proceed about the state's motion for sanctions regarding Mr. Donnelly?
Yes, Your Honor. Your Honor, previously the state had filed a request to have Mr. Donnelly's testimony stricken, in part due to the discovery violation that was asserted based upon his radical change in his testimony. And while the court found that there had in fact been a discovery violation, you found that the state had failed to establish enough procedural prejudice under the Scipio, SCIPIO case, and as well as Evans and Cassica that we had discussed at that time. And so the request for any curative measure at that time was denied. However, I did indicate to the court that we believed that there was some indication that the witness, in addition to that discovery violation and change in his testimony, had apparently been present in court. I did not have the confirmation at that time. However, I have since obtained it. We did provide counsel, and I believe the court as well, copies of photographs, essentially clips from videos. The witness, Mr. Donnelly, was in fact present at least 2 days of the court proceedings, that being the 25th and 26th of January, seated with or immediately behind the defendant in the defendant's family section, and is captured on those screens and is present. I don't think there's even any real dispute that that is him. My understanding is that the concession is that it is in fact that witness. It is subsequent to his sitting through 2 days of testimony, which included a number of witnesses, including Diana Smith, the crime scene tech, and significantly Jane Serdyka, who identified the voice that she heard screaming as a younger man's voice, a boy's voice, I think was her word, something to that effect. Following his presence in court, the witness went home on the weekend, decided to listen to the tape, contact Mr. O'Mara, and we know the history from there. I will point out that even since that time, we have learned that similar things have happened with 2 additional witnesses. As we learned yesterday during the testimony of the defense witness, Mr. Shoemaker, witness John Good, who remained under subpoena and subject to recall, actually met with defense counsel as well as Mr. Shoemaker to discuss and address and adjust and therefore change the defense animation exhibit. Further, right here today, we heard from Ms. You'll have to forgive me, Bertalan, who also indicated that she was present and had watched, or maybe not present in court, but had watched and participated, had watched and observed at least a portion of the trial proceedings, including the testimony of, I believe she said, the defendant's uncle. And so we have, I think, established now, as far as procedural prejudice goes, that the witness in question, Mr. Donnelly, subsequent to sitting in court for 2 days, took it upon himself, I think is his representation, to go ahead and do something which turned him from a, as the case law indicated earlier, a non-witness into a witness. And Mr. Good certainly was in contact with and discussed potential testimony as well as actually a defense exhibit, again, in violation of the rule of sequestration. As it relates to sequestration, I think that the relevant case law as it relates to what to do about potential violations of that rule is set forth in the 4 cases I provided to Your Honor. Again, I think the Scipio and Evans and Cassica line of cases indicate that there does need to be some showing of procedural prejudice. I think the change in testimony as well as the discussions had with Mr. Good in particular, as well as to a lesser extent the third witness that we heard from today, Ms. Bertalan, certainly the cumulative effect of all of those are the ones we know about at this point in time, have sufficed from the state's perspective to establish that there has been some procedural prejudice now, sufficient for that. As far as the violation of the rule of sequestration, obviously the court has contempt powers over and above and independent of any of this. However, the cases that I've cited to the court are, first off is the McKinsey, McKinzie, which is the first DCA case, 845 Southern 2nd 316. And the first issue, or the first order of business, is to determine whether or not a violation was with knowledge or consent or connivance of the defendant or his counsel. I believe, as to Mr. Good, the representation I've heard is that certainly that was with the knowledge of counsel. I don't know. I think the representation as to witness Donnelly has been that that was without necessarily the knowledge of counsel, although whether defendant or any other member of his family knew, I think is certainly open to question given the location in the courtroom that the witness was observed. Second issue is if it is not with such knowledge, connivance, or consent, then the second way to determine this, and I'm reading from page 2 of the court's copy at the bottom of the left-hand column, second test to determine whether a sequestration violation should preclude the witness from testifying, and the state's position is, since they've already testified, the remedy is, at least as to Mr. Donnelly, the prior request to strike his testimony and give a curative instruction, was put forth in Steinhorst versus State. That's Stinhorst. The Supreme Court restated an earlier holding from a case called Dumas, D-U-M-A-S, further explained that the test to determine whether to exclude a witness is whether the sequestration violation changed the witness's testimony from what it would have been had the rule not been violated. So again, before I get to the other cases, the change in the testimony, certainly there's been a change in the exhibit, the animation, as testified to by Mr. Shoemaker, and I think Mr. Donnelly's change in testimony is pretty radical and pretty evident. He went from testifying in his deposition that he hadn't heard anything and didn't recognize a voice to testifying at trial that he had heard something now and did recognize a voice. The next case is Scott versus State. That's 17 Southern 3rd, 766. It's a case from the 4th DCA. And I believe it's referenced as page 4 of the opinion in question, or the copy. I'm sorry, beginning on page 3 and continuing on to page 4. But beginning on page 3, in this scenario, there was a defense witness who was present in court and then opted to express her desire to testify. She was attempted to be called by the defense. The court ruled, much like this court has ruled, that there had been a discovery violation. I don't know that this court has yet determined whether that was willful or substantial, but the trial court in Scott did, and expressed concern about the violation of sequestration, and then said that the court believed and found that the defendant was not acting in good faith, but purposely trying to thwart the prosecution, including dropping the witness on the lap of the prosecution at 1:30 yesterday. I think the court's comments in that case are illustrative. The court said, I'm mindful of the law, but I think that Mr. Scott has been knowingly and intelligently making certain decisions in this case to his advantage and to the prejudice of the state, and to allow this witness to testify at this time would be, and the court finds, will be prejudicial to the state. The court found that a Richardson discovery violation, and there is prejudice to the state in this matter that cannot be reasonably overcome based on the totality of circumstances. The court goes on to say, at the bottom of that column, although the rules authorize a trial court to exclude a defense witness because of failure to disclose the witness, the law has well established the exclusion of a witness as a severe sanction, which should be resorted to only after the alternative available remedies have been fully considered and deemed insufficient. In this case, as to witness Donnelly, there is literally no way to unring that bell other than a curative instruction and instruction to disregard his testimony. So while we recognize that what we're asking for here is not quite the nuclear option, but a severe sanction, I believe the case law supports that it can be done. The Scott court approved that in that scenario. The next case in order is Steinhorst itself, which is the Florida Supreme Court case from 1982. It begins on, I believe, page 7 of the copy of this court's opinion. At the very bottom, head notes 8 and 9, where they're again referencing the old Dumas case. And they indicate that Dumas does not outline the circumstances under which a court may properly exclude a witness for violating the rule. The test, however, is whether the testimony of the challenged witness was substantially affected by the testimony he heard to the extent that his testimony differed from what it would have been had he not heard the testimony in violation of the rule. Defense counsel in that case tried to show the testimony of the witness may have been affected by what he heard. The state attorney elicited testimony contradicting this. The court made a determination in the ruling. Finally, the Dumas case sets forth the older test, still valid, but as I think Scott made clear, only one of a couple different possible ways. On page 2 of the opinion, in the right-hand column, if the witness disobeys the order of withdrawal while he may be proceeded with against for contempt and testimony open to comment to the jury by reason of the conduct, he is not thereby disqualified, and the weight of authority is that he cannot be excluded on that ground merely, although the right to exclude under particular circumstances may be supported within the sound discretion of the trial court. Your Honor, the state's position is that we believe, given both the nature of what went on, particularly as to witness Donnelly, to a little lesser degree witness Good, and to a significantly lesser degree Ms. Bertolin, as well as the cumulative nature of it and the radical change that occurred to both witness Donnelly's testimony as well as the exhibits and items discussed by Mr. Good in connection with Mr. Shoemaker's testimony. The state believes and would renew our request. Obviously, the court can proceed in any fashion it wishes via contempt proceedings against any of the three witnesses, but we would renew our request as to witness Donnelly that the court issue a curative instruction to the jury and order his testimony stricken or a combination thereof. Thank you.
If I may, Your Honor. Mr. Manti. If I might approach, Your Honor, with some case law supporting different conclusions. I don't know if we're now opening the door, so to speak, to all those potential violations. We want to talk about Mr. Good and I forget who, Ms. Bertolin, but maybe we can add to the list Shipping Bow, who seemed to have had a conversation with the state attorney's office where he materially changed two particular parts of his conversation.
I think that is a violation of the rule of sequestration for the attorneys to have a conversation with the potential witnesses.
I didn't think so. It just seemed to be being argued by the state. So let me focus my concern with that argument.
Well, let me just, before you start your argument, as far as Bella Tran, who testified today, the state covered that in cross-examination. That's a non-issue at this point.
Okay.
The state hasn't asked for any sanctions regarding Mr. Good, so that's not an issue as to this point. So it's as to Mr. Donnelly.
My only concern is that if they're referencing these as though they want to sort of pile on and suggest that you should consider that we've ignored the rule all over the place, I have to respond to it.
The court is very concerned over the fact that there are 3 alleged instances of violation of the rule from defense witnesses, and that's something that should have been known by counsel to not have occurred. The court will tell you that I am investigating the possibility I think the person may have been on both witness lists of another person who may have violated the rule of sequestration, although they have not been called as a witness, but I am investigating that also, so I wanted to inform both sides. And
Great.
If you want me to tell you at a later time, I don't want to say the name
Sure.
until I conduct the investigation.
That's
But I
fine.
will tell you up at the bench if you
Sure.
want to know after you finish your argument, but please go ahead. And
As to the court's
proceed.
concern regarding Mr. Good, let's clear the record on that. Mr. Good and Mr. Shoemaker never spoke. Mr. Good was shown by me the animation to confirm with his trial testimony that it was accurate. He told me it wasn't. I had him tell me, and I knew, of course, from his testimony, the areas of concern. I then went to my expert, an expert who, as this court knows full well, could have sat in the back of the courtroom throughout the entirety of the trial in order to get that information. I think it's absurd to suggest that an animation expert can't get information from trial testimony when it is that very trial testimony that he is supposed to do. So,
in all due fairness, it was my questions of Mr. Shoemaker yesterday or last night during his testimony when he said he got the information from a conference with counsel and another person. I asked who was that other person. So that came from the court asking the question.
okay, just so we're clear, they never spoke because I was the intermediary to show Mr. Good the animation, he said, no, they weren't there, they were here, and I went back to my expert to make sure they came into comport with the trial testimony. So that's how the John Good issue did or did not occur, just so we're clear on that. And I guess we're not going to talk about Celine Bahador's change in testimony either, since that was just directly to Mr. De La Rionda.
No, yes, I think
Okay.
that the witnesses are allowed to talk to the attorneys.
And there's, I guess, the discovery violations for failure to notice us will be taken up at a later time if I
Right.
file a motion.
This is relating to Mr. Donnelly, that the evidence presented to the court by way of pictures is that
Okay.
he was sitting in this courtroom after the rule of sequestration had been invoked.
Okay, and let's talk then about the substance of that, and I'll then get into the case law. Mr. Donnelly was here, it seems, from my review of the evidence given to the state on days 2 and day 3 until the first morning break. And we'll have some testimony as to why he was removed from the courtroom at that point. Here's the testimony that he was exposed to that may have affected his testimony. Because I think, as we get into it, obviously, the impact on a witness and the whole purpose for the rule of sequestration is to avoid infecting one witness with another witness's testimony. So he did hear from Wendy Dorival. And you know her testimony as... So he heard that. It seems, at least he was in the courtroom for that. He heard Ms. Dorival. He also then had an opportunity to hear Donald O'Brien, the Homeowners Association. And then he had a chance, after that was done, to listen to Ms. Celine Bahador, a person who never talked about the 911 tape or listened to it or heard anything, but had her own sort of interesting take on the evidence presented and her view of it. And then Sergeant Ramondo came in sort of just to bring in just information, no substantive testimony. Similar with Diane Smith. She came in and identified a lot of exhibits, so he was able to sit through that. But there was nothing having to do with voice identification whatsoever. The second day, he heard, I guess, or at least was in the courtroom for Mr. Dyker's testimony. It was during that break that, and I'll proffer that Mr. West noticed that Mr. Donnelly was in the courtroom and had him leave, but we'll proffer that if necessary. So he was able to hear at least the first half of Mr. Dyker's testimony, during which he didn't say anything about anything. It was the second half. But even if he was here for that, you know her testimony to be that she heard somebody scream. She didn't listen to the 911 call. She didn't opine regarding the 911 call. So he was out of the courtroom at that point. And he's, of course, present and waiting all day to testify to acknowledge this. But just so we're clear as to the violation, we also need to be clear as to what he changed, because I contested the state's suggestion yesterday that he changed his testimony. Because I said, well, he added to it, but the case law that we talk about, and that I'll talk to you about in a moment, really speaks to the infection of that testimony. It really speaks to how a witness has changed their opinion regarding something. What he did was not change his testimony. He added to it by, for whatever reason, waiting until 2 or 3 days before trial or during trial to make whatever that emotional decision was he went through to actually listen to something which he listened to. But that was not a change in testimony, though it is added to it. And then the question is, did the violation of the rule that obviously occurred infect that testimony? I'll suggest to you, since what he heard had nothing to do with what he eventually testified to, that it didn't. Did it prompt him to finally come to grips with the fact that he should listen to the tape? Yeah, maybe so. Maybe it did. But to the substance of the effect, we then have to look to some of the cases that I presented to you. Del Monte, which is a 1985 Third DC Act case, which interprets 616.1, sort of gives us some insight, because you need to make a determination whether or not the rule has been violated, and you need to look into the circumstances as to what you should do with it. And Mr. Manti was straightforward when he talked about the sort of seminal case talking about this, which is the Dumas case, a 1977 Florida Supreme Court case. And basically, what that you need to look into is to get an identification of whether or not there's been some connivance or collusion between the two, and whether or not we did this in some form or fashion to just, in effect, violate not only the geography of the rule, was he in the room, but the underlying substance of the rule. And I would suggest to you that under the Dumas case, the state has woefully failed to suggest any case law that identifies that a willful violation occurred, nor a substantive violation that may have occurred. The other case law, if I might have just a moment to find it. Deals again with this court's sort of requirement to make an identification of the violation, the substance of the violation, and whether or not it's appropriate to issue any sanctions. If so, then you have the right, the most significant of which, or the most severe of which, is that you can exclude the witness from testifying. Certainly, there's nothing in the way this matter occurred as to Mr. Donnelly that suggests not only was it not the defense collusion or connivance or even knowledge, but neither Mr. Donnelly's, and you'll hear testimony from him in a moment, but to proffer it if the court were to allow, when the family, we weren't calling him as a witness. He was on the witness list, but as you know from what we did call him for, specific to the voice, that we were not calling him for any other reason. There was nothing that we were bringing him for substantively until Saturday came and I found out that he had relevant testimony concerning voice, that he was even being called as a witness, just so we're clear about that. But he was definitely on the, I'm not suggesting that that takes him out, but I think that it does affect our presentation and what we were going to do, so that the idea that he may have been around would not have even sort of been effective to us in the way we were handling our witnesses. And I think what happened was once the state invoked the rule and refused to allow Mr. and Mrs. Zimmerman to be here, and Shelley Zimmerman was here by herself, that she requested Mr. Donnelly to join the seat, I guess the row behind her. And that was just so you understand sort of how this whole thing began, with Mr. Donnelly coming into office support to Ms. Zimmerman. And again, since I had never met him, Mr. West, I think, met him at his deposition, but we had certainly not pre-tried him as a witness, as we've heard some testimony here before, because, just so you're clear, we had no intention of calling him. He just had nothing substantive to offer. So that just sort of comes in mind with this suggestion that we had any knowledge or connivance or collusion with the witness. So if, in fact, there was a technical violation of the rule, then the question is, what is the remedy? Before you consider any remedy, I think that you need to find that, in fact, not only was there a technical violation, but there was some true substantive violation. That, in effect, having violated the rule, he gained some knowledge that was able to sort of mold into his testimony before the court. And there's been no finding of that. There's been no evidence or suggestion of that. And in reality, we know what his testimony was, because it was quite limited. It was limited to testimony that he created, if you will, on Saturday before he testified. And if I'm remembering correctly, and I am, that was after he had removed himself from the courtroom some 5 days before, on that on that Wednesday morning, during the morning break. So again, if we sort of look at what happened, he was in the courtroom during a time that he wasn't going to be a witness, but still on the list, left the courtroom when advised to by co-counsel, and stayed away from both the courtroom and the trial testimony until he took on himself to listen to the tape, came to me, talked to me, and I presented him as a witness. So I don't believe that there has been any showing under the cases I presented. Again, Del Monte, Dumas, there are some other cases, but they stand for very similar presentations. Bizard, B-I-Z-Z-A-R-D. Just for the site purposes, that is 674 Southern 2nd, 1382. And Atkinson, federal, I'm sorry. Atkinson versus State, 317 Southern 2nd, 807. Wright versus State, a Supreme Court case back in 1985 that does give some good insight into what the court should look at before making a determination to exclude any testimony. And again, the benefit in a case like that goes towards the admission of testimony and certainly towards the defendant's right to present testimony supporting his defense. There are other cases. McKinsey was also cited by the state. I won't recite that now, but only to state that the entirety of the case that I presented, from the cases I've cited to McMahon at 104 Federal Reporter, 3rd, 638, Stiles versus Bergeron, Bargeron, 559 Southern 2nd, 365, certainly give the court discretion in making a determination of what sanction to impose, but all stand for the proposition that before any sanction is imposed at all, you need to have a quantum of guilt before you impose a sanction. There has been no guilt shown. There has been a technical violation without substance, and though it is unfortunate that it occurred, it was certainly not, as the state might have suggested, some course of conduct, because I think Mr. Good is now a non-issue as to how that occurred. I think that's not only not a violation, it's wholly appropriate and necessary for an expert to properly present his expert testimony. And Ms. Bertolon.
Your sequence of events here, you had indicated that Ms. Shelley Zimmerman wanted Mr. Donnelly to be in the court with her. However, she was subject to the rule of sequestration also, and that occurred either at or during opening statements. So she wouldn't have been here for the first or third day of trial, actual trial testimony.
No, she wasn't here then, but she had made the
Well,
request.
but you said that he came to support her.
My understanding was that she made the request to come by and support because Mom and Dad were excluded from the courtroom. Then she was excluded as well, but she asked for him to support George, in effect, Mrs. Zimmerman, by sitting in the row, but he couldn't sit in the family row. He sat in the row behind her.
Well, I don't know I'm not clear as to what all the seats were, but my impression is to my left, the very first row is supposed to be a buffer row with law enforcement ability to be on there. The second row is the Martin family row, and they can choose who they want to be on that row, and they have to notify the sheriff's office and Ms. Kennedy regarding who they intend to have on that row. And then the rows behind them, except for the last row, which is media, but the rows in between are lottery. People have to go by and get a lottery to be able to be part of the public. To my right, the very first row is the buffer row, law enforcement and others. The second row is the Zimmerman family row, and they have to go through the same procedure that they have to have authorized who appears or is allowed in the courtroom on those rows. And the rows after that are media rows. Am I wrong in my seating arrangement? So are you saying that Mr. Donnelly was seated in a media row and not the Zimmerman family row?
I don't want to offer facts beyond my knowledge. I had not met the man. I've seen pictures, so I know that he was in that side. I think Mr. West, had approached me a moment ago with some better insight on the facts. I don't know. I don't want to have co-counsel argue, but maybe he can clear up those facts. I just know that I saw pictures of him in a courtroom on the right side. My understanding was that he was requested to appear to offer support to George because George's family was excluded. And beyond that, Mr. West may be able to offer some factual insight.
Okay, Mr. West, please.
Well, of course, the issue of whether or not Mr. Donnelly was here, I think, has been addressed, that he was here on Tuesday and then part of Wednesday morning, and which witnesses may have testified during the time he was here, I think is addressed. I had met Mr. Donnelly at the time of his deposition, so I was able to recognize him. And when we took that morning recess on Wednesday morning, as I was exiting the courtroom, Mr. Donnelly was standing there and said good morning, and we shook hands, I believe. That was the first time that I noticed that he was in the courtroom. Certainly Mr. O'Mara didn't, because he wouldn't have known how to recognize him. The clerk would have the time when that morning recess took place, but it was whenever that was, as I recall. I mentioned to Mr. Donnelly when I recognized him that the court had invoked the rule of sequestration and that he would have to leave the courtroom and would not, as a possible witness, would not be able to attend any of the court proceedings. He apologized to me, acknowledged that, of course, he would do that, and didn't express any knowledge specifically about knowing the rule had been invoked previously. To the extent that that was not communicated to him, that's the responsibility of counsel or staff. I don't have any question in my mind that Mr. Donnelly was not specifically informed about that. There's a couple of hundred witnesses on the list. There were efforts made to contact the witnesses that we anticipated would likely be called, and as Mr. O'Mara said, we did not at that time think Mr. Donnelly was on the list. So that's basically it. I didn't tell Mr. Donnelly, nor did anyone with my office tell Mr. Donnelly specifically prior to him appearing in the courtroom that the rule had been invoked and that he could not be here. I don't believe anyone specifically from Mr. O'Mara's office told him. To the extent that didn't happen, it's our responsibility. I have no reason to think Mr. Donnelly flaunted or in any way disobeyed an order that he was aware that the court had put in place through the rule of sequestration. So all of those facts would suggest that the violation was inadvertent on his part, and to any extent that there was some responsibility for it, it lies with myself or with staff.
Okay, thank you.
As to the Shelley Zimmerman issue, I
Or
have
to where he
limited.
was seated?
Pardon me?
Was he
I-
seated in the Zimmerman what's referred to as the Zimmerman family row, which would be the second row to my right?
I can't speak to that because he wasn't
I
seated.
can't tell by the
He wasn't
pictures.
seated when I saw him. He was standing in the corridor here, exiting a row, but I didn't note specifically which one it was. The information I had was that when the rule was invoked and all of the Zimmerman family that was on either the state's list or ours was excluded from the courtroom, no exceptions, and that because Ms. Shelley Zimmerman, who of course, as the court will note, the state did not call, but was nonetheless excluded from these entire proceedings, asked Mr. Donnelly, could he be here as support for Mr. Zimmerman? So that's my best understanding of the sequence. I was not party to any of those conversations.
I'm fit of the question. He was in the second row, Your Honor.
Okay, thank you.
2 points based on what I've heard, Your Honor. McKinsey, which is the 845 Southern 2nd 316 case, says as follows. Where the violation was with that knowledge or consent of counsel, the testimony must be excluded. That is under Head Note 1. What I've just heard is that it was known that the witness had been here. It was known that he was then told he had to leave because of the rule. Later on, he was in fact disclosed his new testimony, changed testimony, or added testimony, however we want to characterize that. And the fact that he had previously been here in violation of the rule was disclosed neither to this court nor the state. Scipio, which is 928 Southern 2nd 1138, says only if the court can determine beyond a reasonable doubt that in this case the defense, but the state, was not procedurally prejudiced by the discovery violation, can the error be considered harmless. I would point out that even accepting everything we've just heard as true, it would certainly be within the court's purview to find that that's exactly what has happened here and that his testimony, in fact, under McKinsey, must be excluded, irrespective of the Dumas analysis. As McKinsey makes clear, these are two separate analyses. One is where counsel knew about the violation and it was not disclosed. And the other is, if counsel did not, we then go to all the Dumas factors about whether the testimony was in fact infected. I would point out that Mr. Crump was also forced to be absent from the courtroom and never called. Thank you.
Okay, 616.1 is the rule of sequestration and the possible sanctions. And the rule basically provides that court would determine that a violation had occurred with the knowledge or convivence of a party or counsel. It may then exclude the witness only if it finds that the testimony of the challenged witness was substantially affected by the testimony he heard, to the extent that his testimony differed from what it could have been had he not heard testimony in violation of the rule. And I think that that is very telling to the court. And on one hand, the court is very, very, very concerned. For those who want to know, that was 4 varies. About the rule of sequestration and the witnesses and counsel abiding by that rule. And the question comes whether or not the witness themselves had the knowledge. And based upon what I heard from counsel, I do not believe that Mr. Donnelly had the knowledge because it was relayed to the court that he was not specifically told. In a case like this where there's a couple of hundred people on a witness list, it is a little insurmountable to notify every single person on that list that the rule of sequestration has been invoked, and especially in light of the fact that not even, one half of those witnesses were called during the trial. So I cannot make a finding that he had the knowledge. Now, would his testimony have changed from what he heard? I am not making that finding either. So the motion for sanctions is denied. And if counsel will approach for just one moment. All right, the next order of business is going through the proposed jury instructions and knowing that there may be some suggested changes to some of the substantive ones. The court wanted to go through just the general instructions at this time to see if we can at least have an agreement as to those. First one, although it's not membered, it's just thanking the jury for their attention during the trial and paying attention to the instructions I'm about to give. Is there any objections from the state to this instruction?
No, Your Honor.
From the defense? Okay. And Mr. Zimmerman, you don't have to stand up. Do you have a copy of these instructions that you can look at them with us?
Yes, Your Honor.
Okay, if you'll please do so, I appreciate it. Yes. Okay. The very first page is just the style of the case. The second page is what I just read.
I'm sorry, were you addressing?
No, but you may be seated.
No objection. Is that what you're asking?
Yeah, I wanted to make sure Mr. Zimmerman had a copy in front of him.
He does, and he's reviewing them with us, Your Honor.
All right. Then the second page is the statement of the charge. Any objection from the state?
No, Your Honor.
From the defense?
No, Your Honor.
Neither one of you have to stand while we go through these. Will reserve as to the homicide instruction because it's substantive. And any suggested changes by either side, if you could give them to the other side tonight via email so we can discuss them tomorrow. The same would be second-degree murder instruction. The next, we'll reserve that until the morning. The next one is possession of a firearm and discharge causing death. Is there any objections to this by the state?
No, Your Honor.
By the defense?
Substantively, no, Your Honor. I believe that it's appropriate based upon the charge. We might readdress that when we go over second degree, but I think it's accurate.
Okay. The next one is when there are lesser included crimes or attempts, and what the state has listed in the proposed instruction is manslaughter and aggravated assault. Is the state requesting these lessers?
Yes, Your Honor.
Any objections from the defense?
We object, Your Honor, and I think that would be something to take up tomorrow.
All right. Manslaughter is the substantive one we'll bring up tomorrow. Aggravated assault is the substantive one. Possession of a firearm and discharge causing death, is that a... Is that the same as the one that,
Because I don't see it in mine the second time, Your Honor. I thought we just addressed that one.
It is, as it relates to the aggravated assault, lesser is where it is.
but it's the same
It is.
instruction, and when the instructions are read, would there be any objection to not reading it a second time? Okay.
I think that as long as there's a reference made and we can sort of, if the aggravated assault lesser is given, as long as there's a reference made to the use of a firearm before, because that's the 1020 life enhancement, and there are separate ones for aggravated assault than there are for second-degree murder.
Right. The next instruction is the justifiable use of deadly force, and that's going to be subject to discussion tomorrow. And please, both sides take into consideration the changes that are currently before the Supreme Court on that instruction, so we need to have some agreement as to how that's going to be presented to the jury. Plea of not guilty, reasonable doubt, and burden of proof. Any objection from the state?
No, Your Honor.
From the defense?
No, Your Honor.
Date of crime, any objection from the state?
No, Your Honor.
From the defense?
No, Your Honor.
Venue, any objection from the state?
No, Your Honor.
From the defense?
No, Your Honor.
Weighing the evidence, there's 1 through 5 are always given, and then we have 6 through 10. Is the state requesting any of the 6 through 10?
I believe certainly 8 should apply, and I believe that is the only one the state would be requesting.
Is the defense requesting any others of 6 through 10?
None of those, Your Honor. I'd like to have a presentation by the state on the inconsistent testimony.
Well, both sides have tried to impeach by deposition testimony or other testimony of the certain witnesses, so I do think that that does apply.
Fair enough.
Are there any 6, 7, 9, or 10 neither side is requesting?
No, Your Honor.
Can you please prepare a new instruction that has 1 through 5 and then number 8 as number 6?
Yes, Your Honor.
Thank you. Expert witnesses, any objection from the state,
No, Your Honor.
from the defense?
No, Your Honor.
Defendant testifying will not be given, so defendant not testifying, any objections from the state,
No, Your Honor.
from the defense?
No, Your Honor.
Defendant's statements, any objection from the state,
No, Your Honor.
from the defense?
No, Your Honor.
Rules for deliberation, any objections from the state,
No, Your Honor.
from the defense?
Other than I think, I don't know what we want to do with possibly 7. I don't think there were any questions written that were not asked by the court. A couple of the jurors asked some oral questions more along the lines of, could a witness speak up, or that sort of thing, so I don't think 7 needs to be there.
Is there defense agree with that?
We do, Your Honor.
So number 7 will not be given if I can have an instruction that takes out number 7.
Yes, Your Honor.
The next instruction is regarding notes. Any objection from the state,
No, Your Honor.
from the defense?
No, Your Honor.
Cautionary instruction. Any objection from the state,
No, Your Honor.
from the defense?
No, thank you, Your Honor.
Verdict. Any objections from the state,
No, Your Honor.
from the defense?
No, Your Honor.
Submitting case to the jury. Any objections from the state,
No, Your Honor.
from the defense?
No, Your Honor.
And then we have a state's proposed special jury instruction number 1. We'll argue that tomorrow. Are there any other proposed jury instructions that are not covered in this packet from the state?
Not at this time, Your Honor.
From the defense?
I apologize. I was using a copy that I guess I now see it. I didn't have the state's proposed special.
It's the very
It was in
last page.
Last page that they gave me just now. Okay, thank you.
All right. Other than what we've discussed with the substantive ones that may have some changes, are there any other special instructions going to be requested by the defense?
There will be some. Oh, other than the ones we've just discussed?
Right, the
No.
ones that I'm reserving on, changes that may be to that, are there any additional proposed special instructions?
No, Your Honor.
I'm going to need a proposed verdict form.
Yes, Your Honor.
And if you can give a couple of scenarios, one that includes both lesser included offenses, one that includes one and then the other lesser includeds, and then they have to include the firearm.
Certainly.
Are there any other matters that we need to take up this time regarding the instructions?
No, Your Honor. Thank you.
Just so I'm clear, the defense will be requesting some proposed special instructions, but we're going to get
Just
those later?
changes to the instructions on the substantive charges. Is that correct?
That's correct.
And those will be exchanged tonight via email.
That's special. I apologize.
I don't
Well,
want
you could talk after court about that, and otherwise they will email it to the state overnight so we could be prepared to talk about it in the morning. Do you think it's going to take more than an hour tomorrow to go over these jury instructions?
hour or so.
So then
according
we'll
to
be
the
back
argument.
in recess at 8:30 because I have the jury coming in 10 for closing arguments.
I'm going to ask that we delay closing arguments for enough time to give both the state and the defense time to prepare for what we have to do tonight, for tomorrow morning, and then for closings. There's a lot of testimony, a lot of evidence, and
All
it
right.
just
We'll
needs to be
begin
organized.
closings at 1. And we'll let the state go through their closings. The defense can do their closing on, tomorrow is what, Thursday, Friday morning. The state could do the rebuttal Friday morning. I could charge the jury, and they will go out to deliberate Friday afternoon. Does that give you enough time?
It does.
Ben, I need to let the sheriff know that we don't need the jury until 1 tomorrow afternoon. And counsel, what time do you want to come in and go over the jury instructions?
I thought you said
9?
8:30, but
8:30 is fine.
I just didn't know if are you asking to change that?
Well, we just talked about it, and you
Oh,
said you
sorry.
wanted time for your closing. I don't know how much time the state's going to need. Do you want to start at 10 o'clock on the instructions? Do you want to start at 10:30 on the instructions? Or do you rather do it in the morning? Because you're not going to start your closing till 1 in the afternoon.
Early in the morning would be better, and Mr. Manti will be representing us. I just need to update my
So what are you
closing
saying, you
argument.
get to sleep later than Mr.
No, I'll be
Manti?
here, I'll be here at 7 or earlier, probably 6:45. But I'm just saying, I would like to have more time to be able to input whatever changes are made into my closing argument presentation. So I would prefer at 8:30 or 9 o'clock if we could.
9 o'clock it is. Court will be in recess till 9 o'clock. We'll have the jury in at 1. Is there anything else that we needed to take up tonight?
Now that we've moved to Friday, does it not make sense to just start closings Friday morning? And then this way we get all the closings in one day and the jury gets charged?
The reason I told you what schedule I wanted is because it makes sense to me. Okay? And it gives you the time, it gives you plenty of time to prepare for your closing. And the state has indicated they don't need any more time, so we'll be in recess till 9 a.m.